Item for delivery of order. This is CRP IO 212 of 2024.
Revision petition dismissed.
Mention.
Please.
Yes.
With regard to item number 17, my lord. This is listed for the first time, my lord. I'm praying on behalf of the appellant. Can it be taken up on Monday, my lord, 11th?
Monday.
Okay.
I love it.
On the appeal being made by Mr.
And thus, man.
and thus learned counsel for the appellant resistal is the matter on Monday.
Item number 3 to 7, my lord. That, my lord, medical pharmacy matter, my lord.
Yes.
Yeah, my lord, today in the motion, there is some difficulty on my part for hearing, my lord. Can it be on a hearing day, any day, Tuesday or Thursday, my lord? I have checked the chart on 19th if possible, my lord. I have taken the consent from my senior.
Yes, Mr. Buragoy.
On 19th, my lord.
If you have some difficulties, I will have to accommodate.
Okay. On the appeal being made by Mr. Gogoi, learned standing counsel for Health Department, having not been objected by Mr. Buragoy, learned counsel for the counsel for the petitioner, resistal is the matter on 19.
19, my lord.
Okay.
Obligation.
Along with other cases.
All, my lord. 3 to 7.
All the matters.
Yes, all.
Please, your lordship, my lord, with due consent of other side in respect of item number 18, my lord.
18.
18, my lord. I am for the respondent, my lord. Our name has not been reflected in the cause list, my lord. Matter may be taken in the next week, any day, my lord.
I am for the appellant, madam. My lord, execution is pending, but we came to know today morning itself. And we'll have copy today during court hours.
Any day in the next week, my lord.
Lordship, on 13th.
Okay. Possible. Your good name?
AHM R. Chaudhary.
AHM
R. Chaudhary.
R. Chaudhary, learned counsel for the respondent.
Number 1, my lord.
Respondent number 1 submits that his name has not been reflected in the cause list. And he pressed for listing the matter on
13th.
13th with consent from the other side. Pair is accordingly allowed. Resistal is the matter on 13th.
May I please, your lordship? With consent of the other side, item number 30. Come up after 3 weeks, my lord.
Item number 30.
30.
30.
30, my lord.
You are for
Respondent, my lord.
your name?
SK Das.
Mr. SK Das, learned counsel for the respondent with consent from the other side. Press for listing the matter. When?
After 3 weeks, my lord.
After 3 weeks. Pair allowed.
Obligation.
Hey, please, your lordship. Is a listing of a matter, your lordship, on 23rd, your lordship.
23rd November. Saturday.
In which column?
Orders column, your lordship.
Orders.
Saturday.
Then 21st.
25th.
25th. Obligation. May I please, your lordship, I beg to mention item number 41. Lordship, we have filed our affidavit. Our affidavit may be called for.
Correct.
Yes, sir.
Hey, please, your lordship, I beg to mention item 10. Kindly the matter will be released at any date next week. My senior is having some personal difficulties.
Your good name?
Tinlung.
Ms. Tinlong, learned counsel for the appellant. Press for listing the matter on
Any date, lordship. as per
Any
the dates
date.
of next week.
On 22nd.
Obliged,
okay.
lordship.
pair allowed.
May I please, your lordship? Lordship, I beg to mention item number 16, lordship. Miss conducting counsel, Mr. O.P. Bhatt is presently out of station, lordship. So matter kindly fix after 3 weeks, lordship.
Your name?
My name is not shown, lordship. I'm on behalf of O.P. Bhatt, P. Sharma.
P. Sharma.
Yes, lordship.
Mr. P. Sharma, learned counsel appearing on behalf of Mr. O.P. Bhatti. Learned counsel for the appellant. Resistal list the matter on
After 3 weeks, lordship.
after 3 weeks.
May I please, your lordship, for mention for listing
When?
13 November, Wednesday,
Under which column?
order,
13. Okay.
oblige.
Miss, please, your lordship. Your lordship, I beg to mention on RLC for listing in
When?
orders column. On
When?
11th, lordship. Monday.
11, no, she already given so many cases.
Then on 13th, Lordship.
14th,
14th. Yes. May I please, Your Lordship, with the consent of the other side, I beg to mention item number 27 and 28 of today's list. The conducting counsel, Mr. N.J. Gogoi, is out of station.
27 and 28.
Yes, sir. I am for the petition alone.
Conducting counsel, Mr.
N.J. Gogoi, he's on leave. He's out of station.
Your name?
S. Dev.
S.
S. Dev.
Ms. S. Dev, learned counsel for the respondents with consent from the other side. Press for listening the matter. When?
On 9th of December, Lordship.
9 December.
9th December. Monday.
Fair Lord.
Still to continue, Lordship, in both the matters.
Interim order pass earlier, shall continue.
Okay. May I please, Your Lordship. Lordship, I got to mention item number 21. Mr. H. L. Moria is a sick, my lord. So matter may be absent only for 2 weeks, my lord.
21.
21. Due to accident, my lord, he is in hospital.
Have you informed the other side?
No, no information. Could not find the other side.
Please,
I will
please.
inform my lord later on.
No. You first inform, thereafter you come.
Yes, sir. I will try, my lord. Right.
For motion item number 1,
May it please, Your Lordship. Fact of the case is, my lord, the husband has preferred a petition, my lord, the respondent hearing, my lord, before the family court for divorce, my lord. We, being the wife, my lord, have preferred this petition for transfer from Guwahati to Sonitpur, my lord. The basic ground for transfer, my lord, is that, my lord, that one proceeding is already pending in Sonitpur. There are 2 children, 8 years and 14 years of age, my lord. The wife is working in a beauty parlor and getting only 4,500 rupees, my lord. So these are the basic grounds on which we are.
Where she has been working?
In Tejpur only, my lord. And 2 children, my lord, and one proceeding is already pending at Sonitpur, my lord. And we have specific statement has been made here in the that says no place of abode at Guwahati, my lord. So with 2 children coming to Tezpur and going back, it's almost for the.
For Mr. L.L., learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring FC civil case number 1079 of 2024 pending before the Court of Learned Principal Judge Family Court number 2 Kamrup M in Guwahati to the Court of Learned District Judge at Sonitpur. The learned counsel for the petitioner submits that the petitioner and the respondent are husband and wife, and their marriage was solemnized in the year
2008, my lord.
2008, and thereafter they lived together as husband and wife. Where?
Both at Guwahati and Tezpur, my lord.
At Guwahati as well as in Tezpur, and they were also blessed with 2 children. And thereafter marital discord surfaced between them, and the respondent herein had instituted one divorce proceeding, being FC civil case number 1079 of 2024 before the Principal Judge at Family Court number 2 Kamrup M at Guwahati. Mr. Lal further submits that the petitioner is residing at Tezpur and she has been working in a beauty parlor, and her monthly income is rupees 4,000 only, and besides she has to
4,500. I'm sorry, 4,500, lord.
4,500, and besides she has to look after her 2 children, and with her meager income it is not possible on her part to contest the aforesaid proceeding at Guwahati, and therefore it is contended to transfer the same to the Learned District Judge, to the Court of Learned District Judge at Tezpur, Sonitpur. Where is the petition and the grounds mentioned therein? Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Proceeding with the next is then 20th of November.
At what stage it is pending?
It is at the stage of notice only. Notice has been issued. We received notice. We have not still entered evidence in the matter. The page 28 this time.
Having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, this court is of the view that a prima facie case for staying the proceeding of FC Civil case number 1079 of 2024 is made out, and accordingly further proceeding of case number so and so is state till returnable date. List after 4 weeks.
Item number 2.
May I please direct you? The fact of the case is, my lord, the petitioners filed a petition under section 276 for Indian Substitution Act for grant of probate of will, which is exhibited by the Niruka, his sister. And this was, the respondent received notice from the Honorable Court and appeared before the Honorable Court that after filing the petition, the respondent was absent. Hence, the case was proceeded exported against them. Accordingly, after hearing the petition, Honorable Court granted the probate to the petitioner, and the order was reflected on page number 12, on 12/9/2018. After that, but after granting the probate, the petitioner filed again a petition on section 151, 150, and 152, correction of the judgment. But Honorable Court, after hearing, reject the petition. This order was already page number 17. And at the filing of the time, the petitioner filed the will in the Honorable Court. But now the petitioner, the respondent filed a revocation case for revoke the probate. And there they filed a 65 petition for secondary evidence, though the original documents is in the case record. But which was allowed by the Honorable District Judge number 2, Nagaon. Against this order, I filed this petition.
So how and in what manner prejudice is caused to you?
My lord, already 2018, from the date of 2018 to till today, I was waiting for this granting, already probate was granted already. Then they will, again, they took time, but only for harassment, not for them. Already original will is in the case record. Then why need for a secondary
There
evidence?
is a allegation of
Fraudulent.
yes.
Which was already in case record. After seeing receiving the notice, they come to the court and filing filing petition, and after that they were absent. And at the time of filing, the will was in court custody. And then when they was come to the court, then they will not see that. Only for harassment they are filing this on the petition. If you go to the page number 17, there's a crystal clear. In page number 18, yes, there says, as per our record, the executor of the will probate will originate exhibited exhibit 1 by examining the two attesting witness VW2 and PW2. Under factor, the weight is in the mind of the court was that will was registered documents by registered seat number emanating.
No, that observation was made at the time of ex parte hearing.
The will was already filed at the time of filing of the case in the custody of the court. Then how can it be possible to fraudulent by the
Before production of the same before the court?
after production the will they was already come to the court and filing petition. Already they ordered for the record.
No, how prejudice is caused to you when the court directed this volume book from the sub register office is directed to
Which
be
was
produced?
already proved in the by Honorable Court in the probate case by the testing witnesses also.
Maybe
But
at that time
process-
the proceeding was ex parte.
Yes, but we are already filing expert evidence after
Maybe now
examining petition.
now the respondents appears and contesting your petition.
Yes, from till 2015 to till date, we are suffering. Last 10 years.
The learned court has only called for the volume book from the sub-register office,
Yes, in it is,
nothing else.
Yes, my lord, but it was already happened in the previous case, which was he was absent.
Hmm.
Expert evidence already, expert already against
No,
them.
no, at
because
that
they
time
were
that
absent.
volume, no. At the time of ex parte hearing, the volume book was not called for.
No, testing witnesses already examined, or they are already produced the evidence.
Hmm.
In revocation case, research already had evidence coming from.
So, madam, you say to set aside this order, you have to show the illegality and arbitrariness by the learned trial court.
Yes, secondary evidence is when it's
Hmm?
necessary. When original documents is not in, we lost or
Maybe,
other
but
documents.
when there is allegation that there is manipulation of the original will, then
Yes, when it will be manipulated before the filing the court, because already we are filing the will in the at the filing at the time of filing the probate petition under section 276, and after that they were came to the court. They saw the records. After that they were absent. Hence the court has proceeded expert against them. They were already filed a petition to
no,
time.
now we are not on that issue. The issue before this court is how the learned trial court has committed any illegality or impropriety.
Yes, original documents is there. Where is the secondary evidence, my lord? Original
There is
already,
while there is
court custody.
allegation,
Filing of the case to till date.
we are dismissing the petition.
We filed the original will at the time of the filing the petition of the 276. But till that to till then that to till that the will is there in the case record.
So, madam, in fair trial, fair opportunity has to be given to both the parties to prove their case.
Exactly, they were ignored the court. Already they ignored the court. They filed. They already came to the court, and after they was absent. This was also took time for a.
Or Miss Medhi learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 28/8/2024 passed by the learned additional district judge number 2 Nagaon, Assam in title in Miss revocation case number 1 of 2020. The grievance of the petitioner in this petition is that the while impugn order dated 28/8/2024, the learned additional district judge has allowed the petition number 2709 of 2023, dated 12/10/2023, filed by the respondent herein under section 65 of the Indian Evidence Act. O. Production of the relevant volume book in respect of the will number 33 of the year 2015 from the office of the sub-register Nagaon, Sodor, as the petitioner in the aforesaid petition has alleged practicing of fraud on the court by manipulating the original will submitted in the probate case number 17 of 2015. Ms. Medhi, learned counsel for the petitioner, submits that only in order to cause delay in disposal of the aforesaid, in disposal of the aforementioned case, the petitioner, the respondent herein had filed the petition number 2709 of 2023 before the learned district judge, additional district judge Nagaon, and the petitioner has been suffering since the year 2015. And in the probate case number 17 of 2015, probate has already been granted in respect of the present petitioner. And since then, the will is in custody of the court, and as such, the allegation of fraud and manipulation is not at all acceptable or believable, and therefore Ms. Medhi contented to set aside the impugned order dated 28/8/2024. Having heard the submission of Ms. Medhi, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record. It appears that the learned additional district judge in Ms. Probate case number 17 of 2015 already granted probate of the will number 33 of 2015 on the petition filed by the present petitioner. Thereafter, the respondent herein filed a petition for revocation of the aforementioned probate. And upon the said petition, Ms. Revocation case number 1 of 2022 has been registered. And in the said proceeding, the respondent herein had filed on petition number 2709 of 2023 on 12/10/2023. Under section 65 of the Indian Evidence Act for calling the original, for calling the concerned volume book from the office of the sub-register, as she has alleged, as the respondent herein has alleged manipulation of the original will and fraud upon the court. It also appears that thereafter the learned additional district judge Nagaon, considering the allegation of fraud and manipulation in will number 33 of the year 2015, has called for the volume book from the office of the sub-register Nagaon Sodor, and also found that if the same is not called for, the petitioner stroke the respondent herein will not be able to establish his case. Having examined the impugned order dated 28/8/2024 in the light of given facts and circumstances on the record, and also in the light of submission so advanced by the learned counsel for the petitioner, this court is of the view that no illegality or impropriety is committed by the learned additional district judge number 2 Nagaon in calling the volume book from the office of the sub-registrar Nagaon Sodor, as the respondent herein in the petition number 2709 of 2023 has alleged manipulation of the original will number 33 and fraud upon the court. It is to be noted here that fair trial, right to fair trial, is right of both the parties. And in fair trial, fair opportunity has to be afforded to both the parties. If the volume book is not called for from the office of the sub-registrar, then the respondent herein will be deprived of an opportunity to prove his or her case. In view of above, this court find no merit in the petition and accordingly the same instance dismissed. However, the learned additional district judge Nagaon is directed to conclude the aforementioned proceeding as early as practicable.
Item number 40.
May I please, Your Lordship? Here, in this case, without service of summons, as per instruction of our client, she appeared, and that's why I have also gone through the case record. In the case record also, there
Then
is
from
no.
who is that this 90 days has to be counted?
Now, learned trial court has counted it from 23/8/23.
From the date
day,
which the council appeared.
the council appeared by filing wakalatnama. And in the impugn order, my lord, in fact, we have filed WS along with that petition for acceptance of the written statement. But from para 10 of the impugn order, that lordship will find from page number 108. Here, my lord, in page number 109 para 12, it is also stated, upon careful consideration of the circumstances, the court has determined that the petition for acceptance of the written statement was.
You are reading page number?
109, my lord. Para 12.
109. Have you filed an additional affidavit?
No, my lord.
So the last page in the case file is 107.
Internal, my lord, page number 6 of the order.
Acha.
Para 12, my lord. I am on.
It is a 106 page number.
Oh,
Yes.
para 12, my lord. Upon careful consideration of the circumstances, the court has determined that the petition for acceptance of the written statement was submitted after a significant delay of nearly 5 months by the newly engaged counsel. The stated reason for the delay attributed to the medical treatment of the defendant number 1 was not previously cited by the former counsel in earlier applications. So this lack of disclosure indicates that the defendant did not approach the court with clean hands. Accordingly, in adherence to the principles of equity, the court finds no justifiable reason to accept the written statement through the application of his jurisdiction under section 151 of the CPC. Consequently, the court is of the opinion that defendant number 1's prayer lacked merit and is thus rejected. However, the defendant will be allowed to present before the trial and cross-examine the plaintiff's witness on relevant legal points should such circumstance arise. And in this manner, it was disposed of. But the fact of the matter is that, my lord, till date also, the suit is pending for SR and WS upon the defendant number 2 and other pro forma defendants.
No, that cannot be a ground for allowing
So,
your petition.
In fact, no prejudice will be caused to the plaintiff.
No, that is a.
If our WS is accepted, even at this stage also, my lord.
No, the stand taken by the court is that in the earlier application, you have filed 2 applications.
Yes, my lord.
First one was by the earlier counsel.
So, on the date fix, he filed applications seeking some time to file WS.
In that application, you have not
Medical ground was
mentioned
not stated.
about your medical condition.
Yes, my lord. So the newly engaged counsel, they appeared on 6/2/24.
And thereafter, matter was fixed on 22/4/24, but in between on 2/4/24, this application under section 151, along with the WS was filed, my lord.
Hmm.
My lord, dispute between two sisters, family matters, my lord, and matter is still pending for SR and WS, and
No,
moreover, my
maybe,
lord, there is a probate case.
Maybe the matter may be between two sisters. But the question of law is involved therein.
Yes, my lord.
After 5 months of rejection of your earlier petition, you have filed another petition with new ground.
Yes, my lord.
Hmm?
Regarding the same property, the probate case is also pending. I am the petitioner there, and my sister is the respondent there. Regarding the same property, my lord. Now she has sought for declaration of right title and interest as well as partition upon the same property, my lord. So if I am the beneficiary there,
No,
and if this,
Mr. Bora, you saw how this order is illegal or impropriety, illegal or arbitrary.
my lord, the matter is that court doesn't say that these are all false documents.
Hmm.
Because when somebody is, suppose they are getting treatment in Kolkata,
Hmm.
as well as in some other places of India also,
Hmm.
there may be some sort of communication gap, maybe, I think, with the earlier set of counsel.
Hmm.
So,
But
furthermore,
Mr.
when,
Bora, Supreme Court has clarified that you cannot entitle to that benefit, blaming the councils.
yes, my lord. But even then, my lord, when people are receiving treatment outside the state of Assam, whether it is possible to send the documents
Hmm.
from that state when receiving treatment, during the course of receiving treatment to the council, my lord.
No, is it your case that for the 5 months
Yes.
you were outside the
Yes, my
state?
lord, I have annexed my medical documents, my lord, from
Hmm.
page number, my lord. From 29, in 151 application, I have annexed those documents, my lord. All the medical documents. My lord, page 29 itself shows that the husband of the petitioner, he was wheelchair bound. This is the history. Already a person in wheelchair bound. Page number 21, 29 onwards, my lord, up to page number 47. Air tickets are also there, my lord, in between. My lord,
Who prepares the written statement by
the newly engaged counsel.
then how she is prevented from sending those documents to the council?
No, at the time of filing this written statement, she was here in Guwahati, at
Hmm.
Maligaon,
Hmm.
which are place of residence.
Hmm.
When the newly engaged counsel filed it, that's why she has provided all the medical related documents.
Mr. Bora, this impugn order cannot be said to be illegal and arbitrary. It is a region order.
But even that, my lord, for the mercy, my lord, some
No,
mercy
no.
may be shown, my lord, for the sake of justice, my lord. Because already a
Mr. Bora,
case is
justice
there,
has to
my
be
lord.
done to both the parties, not only to you. Because of your failing to file your written statement, some right has been accrued on the other side.
Yes, my lord. That's why, my lord, for the part of that, even before the learned trial court, also the matter of imposition of cost was there. So, but other side objected it.
Hmm.
Other side objected it. We are even ready to pay some cost also before the learned trial court.
Okay, we will see and pass the order.
Items for admission, item number 8.
Yes, sir. It will be.
Item 8.
Your Lordship, matter will be passable for timing as my senior is on other.
Okay.
Item 9.
My lord, matter relates to my lord provincialization of service. my lord.
Hmm.
Before I start my learned friends,
May please your Lordship, our instruction is awaited, Lordship.
Hmm.
for
Since when? Since when? Heard Mr. Hussain, learned counsel for the petitioner, and Miss Moore, learned counsel for standing counsel for the education department.
Lordship, 1-3. 1-3.
1, 3, 5, and 6.
Lordship.
5 and 6. None appears for the respondent number 4.
2.
4 and 2. Ms. Moore submits that instruction is awaited and prays for granting her sometime pair is allowed to list the matter
Deputy Commissioner.
on when? Madam Kaur, when you will get instruction?
Sir, Lordship.
Okay, that fix it.
Yes, Lord. 27th.
In the
27th
event
November.
of failing to produce an instruction on next, then the court will proceed to hear and dispose of the matter on the basis of materials placed on record.
Item 11.
We have to suppose file affidavit also, but T. Upomino is out of station because of the mother ailment lawsuit. So some fixed time is granted lawsuit to file affidavit. He have received the instruction lawsuit.
Yes, madam. Or
As
Ms. P.
well.
Burman, learned counsel for the petitioner, and Mr.
As we are lawsuit,
S. Muya, learned counsel appearing on behalf of
higher
Mr.
education, higher education. 1 and 2. 1 and 1,
Mr.
2
D.
and 3.
Upamunda, learned standing counsel for the higher education department. It is submitted that Mr. D. Upamunda is out of station on account of treatment of his ailing mother, and as such, a pair is being made to adjourn the matter and to list after when
After 3 weeks.
2 weeks.
Date will be fixed.
Okay.
For 2 weeks. 25th. 25th November. Item 12.
He also will file affidavit lawsuit. So it's maybe
My
done.
lord, in this matter, my lord,
Hmm.
the respondent number 2 was to file an affidavit, my lord.
Yes, sir.
On several occasions, my lord, they have failed to file their affidavit.
That's true, but 24 meter lawsuit. 24 meter, we have 5 will definitely. And otherwise, case is some, there in division bench has been here also. Otherwise, no, we'll file affidavit for this also.
Almost a year ago.
No, let it proceed. We'll file affidavit.
Heard Mr. Estes, learned counsel
As
for
we
the
are, oh, sorry. Very good.
petitioner, and Mr. S. Bhuya,
Lawsuit.
learned counsel
The higher education. 1 and
for
2.
the higher education department. Ms. Bhuya submits that he may be granted 2 weeks time
Lawsuit.
to file the affidavit in opposition. Pair is accordingly allowed. List the matter on
27th November.
My lord. Highly obliged.
For bail hearing, item 13.
May I please, Your Lordship?
Hmm.
Referred to bail application, my lord. Lordship, can this see FIR as page 17, my lord? Earlier it was rejected by the number 17.
APP is absent. Wait for some time. Next meeting.
For hearing under order 41, rule 2, CPC. Item 14.
Yeah, please, my lord. My lord, can it be taken after some time, my lord? I have blessed.
Item 15.
This is a judgment of reversal. The plaintiff filed a suit for a specific purpose of contract against the main defendant, Sri Rasik Chandra, claiming that an agreement was executed between the plaintiff and the defendant number 1. Regarding sale of a plot of land with a condition that after the amount is repaid by the plaintiff, the defendant would resell or reconvey the title of the plot of land to the plaintiff. The learned trial court, having found no title of the plaintiff, dismissed the suit, and in appeal, the appellate court found that the entry in the mutation record, the name of the plaintiff is there. On the basis of the entry in the mutation record, the appeal was allowed. If I may take your lordship to the trial court judgment, relevant portion your lordship will find at page 47. The issue number 3.
Mr. Biswas,
Hello.
so the substantial question of law you have suggested is not part of the memo of appeal.
It is along with the memo of appeal we file, my lord, in this way, because the certificate we submit, we cannot certify the substantial question of law. Only we can certify the grounds. And if we have to make it a part of the certificate, but the substantial question of law is for the honorable court to decide whether these are the substantial question of law or not.
But is it in accordance with section 3 to subsection 3 to section 100?
Yes, my lord, very much. But it
How?
says the
How?
part of the memo of appeal. But when it comes to memo of appeal, we file a certificate, give a certificate, certifying the grounds stated therein. But once we include it, but before the certificate we have submitted, but we have to certify the substantial question of law also, which is not permissible.
Who said it is not permissible?
But because this is a question of law, but we cannot certify the law. We can certify the
You
grounds.
cannot certify it, but you have to comply with the section.
So this section says 100 part of memo of appeal. It's a part of memo of appeal.
Briefly
It is
state
annexed,
in the memo of appeal. Is it?
it is annexed to the memo of appeal.
Sorry, you amend it. We will not hear you. Mr. Soduri,
My lord, it's up to your lordship.
heard Mr. S. Biswas, learned counsel for the appellant, and Mr. P.K. Roy Soduri, learned counsel for the respondent. List this matter after 1 week so as to enable Mr. Biswas to file this amended memo of appeal incorporating the suggested substantial question of law.
Before the registry will submit this amended post of appeal.
Yes,
Well, this may be reflected, otherwise there will be objection from
not
the registry.
necessary. It has to be invariably before the registry.
But the registry place and objects to the whenever you go there, then they say you file an amendment petition before the court.
No.
One observation, otherwise objection will be
Okay,
there.
before the registry. Okay.
Much obliged.
For bail hearing, item 13.
Lord, regarding the service of notice, my lord, our office, my lord, received it on my lord 2/11. So my lord, kindly like accommodation, my lord, I will report not received, my lord, below. We have sent, my lord.
Scan record. Scan record also into service report.
Okay. Heard, Mr.
You lost for me.
Jay Ulaskar, learned counsel for the applicant. And also heard Mr.
B. Sharma.
B. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that he has not received the service report and plays for granting him some more time, so as to enable him to produce the service report before this court. It is accordingly allowed. List the matter on when.
My lord, 14, my lord.
14.
My lord.
Okay.
Item number 41. Item 41.
Your lordship will pass over the matter for the time being. At my seniors and lens.
42. Item 42.
To my lord, scan copy, call for my lord, not received.
None appears for the accused on call. However, Mr. Sharma, learned additional PP present. Mr. Sharma submits that as per office note. Dated 7/11/2022, scanned copy of the record has not yet been received. Accordingly, it is provided that SSL is the matter. No, SSL issue reminder to the learned trial court for transmitting the scanned copy of the record without delay. List the matter after 1 week.
Item 43.
Totally fix us in the hearing. It okay. It was none appears for the appellant on call. List the matter after voice.
Malaga, add 2 minutes again. Good item, good item. Hello, let's.
Item 19 for orders.
This matter has been listed in view of order dated 38/2024, my lord. What happened, my lord, the respondent of one died during the final hearing, my lord. We have substituted the legal rights, my lord, and we have also filed the amended cost title, my lord. And now the matter is ready for hearing, my lord.
So lordship may kindly fix a short date, my lord. If it's possible, lordship,
And fourth question.
let it be on 4th of December, my lord. Or third.
Fourth question.
Amended cost title. When you have filed.
Yes, my lord,
Flag.
it is flagged as X, flag X. It is reflected in the office note dated 16/9.
Yes, today is fixed for what purpose?
Well, only for that, we have filed that amended cost title. Therefore, it will be go for hearing.
Okay, heard Mr.
Yeah, agree.
D. Hazarika, learned counsel for the appellant, and Madam
JM Kumar.
J.M.
Kumar.
for learned counsel for the respondent. Mr. Hazarika submits that pursuant to order dated 38/8/2024, he has already filed the amended cost title of the appeal. And as such, the matter is ready for hearing. And accordingly, it is provided that SSL list the matter on
December 10th, 10 December.
And December.
for hearing.
My lord.
Item number 20.
Okay.
You're for the respondent,
Respondent number one.
respondent number one, but who is for the appellant?
I exactly do not know where you now.
চিনি পাই নেকি? উল্লাহ বুলি আছিলে, বিউল্লাহ। চিন্তাবাদ। এইটো ইমান লেভেলৰ লিষ্টে হোৱা নাই। বহুত আছে। নটিচ দিব লাগিব নেকি এইবোৰ? দীপৰ গোহাঁই আমি আছে নেকি? এটাতো কেছ Wait for some time. Court master will call the council.
Minor, I want to submit one thing.
Yes.
That the sole respondent Anwar Hussain has already been expired some months back. I got his information on the yesterday.
Acha.
So this may kindly be notified to the appellant under the provisions.
Okay,
of the
that's all right.
22 Rule 10.
Therefore, court master will call the council.
No, from my side, I'm submitting that the respondent is expired, so appeal cannot proceed against you. And secondly, my duty is to inform the honorable court as to the date of the respondent under the provisions order 22 Rule 10A. Accordingly, I informed the honorable court as to the date of the respondent number. Now the opinion may take steps.
So that's all right. We'll pass the order. But the name of the council for the appellant is reflected. Where? Yeah. Yes, Madam D. Borgohain. Are you the appellant in this RSA 248, 284?
Yes, Lordship 21, RSA 85 of 2014. I mean item number 21.
Acha, okay. Okay, okay. Okay, contact number is available. Court master will contact the council. Wait for some time.
Item 21.
In this matter, there are several ayes. In fact, during the pendency of the proceedings, the respondent number 1 has expired. And we came to know that very late, and thereafter we file an application, order 22 Rule 4 for substitution. And there is also some delay in preparing that application. So we file an application for condonation of the delay also. Then obviously abatement, suit was abated because of the delay. And we have filed an application for setting aside the abatement as well as the delay that has resulted in filing the application for setting aside the abatement.
No, that's all right. You tell me the number of IA
Yes, IA for
condonation of delay.
condonation of delay in filing the application for substitution is 1659 of 2023. One 2023. That is the application for condonation of delay in referring application for substitution. The respondent have already filed their objection also here.
In which petition? This petition?
Lordship.
In this petition for
Yes,
condonation of
yes.
delay?
Yes, it delay, etc. What they say is that we were aware of that and that intentionally we have not prepared. Lordship, we have stated here.
No, but
as-
in this IA, no order has been passed.
no order has been passed because repeatedly they were the ones who were taking time repeatedly, respondents. And there was a duty cast on him also under Order 22 Rule 10A to inform the court if the client, his client has expired. Even that was not done. That is why in such cases, probably there is no point in keeping this pending. It can be allowed so that the appeal can move on.
And that's all right, but in this IA, we have to issue notice because there is no record that the other side entered appearance here.
No, they filed the objection.
Where?
Yeah, on behalf of the prospective substituted head.
Where?
In all the applications, in all the IAs they filed.
Madam,
Your
this
Lordship,
IA
I
number
civil
1659,
Yes, they are
no
also-
order is passed.
They filed. Affidavit in opposition
Hmm.
on behalf of prospective respondents. Serial number of that probably will be in 11, it's shown as 11 here in our records.
Yes, obviously.
Affidavit in, counter affidavit, tag X.
Order to put.
Right to the tag the seal of it. It would make it 165.
মানুহটো এক্সিডেন্ট হৈ যাব কৰি আছে বুলি কৈছিল Madam, the counsel for the respondent, he meet an accident and he is perhaps now bedridden. In another case, one counsel has informed this court about him.
Mr. Moria.
Yes.
Moria. Then I will.
We'll fix a short date. Let him come.
No. Yes.
Third, Ms. D. Borgohain, Lord Counsel for the appellant. Stroke applicant. None appears for the respondent. Stroke opposite parties on call. Place the matter on.
On 25th.
25th.
The government also there, 2 and 3 lots.
Acha. Also heard Mr. Gogoi, Learned Counsel for the respondent number 2 and 3. 2 and 3.
Number 22.
My please, Lordship, in this matter, as per order dated 2/9/24, your Lordship, registry was asked to substitute the name of the legal heir of respondent number 3, your Lordship, which has been done, your Lordship, and LCR has been received, so kindly the matter be fixed for hearing, your Lordship.
Heard Mr.
S. Paul, your Lordship.
S. Paul, Learned Counsel for the appellant. But the respondents?
Respondent number 3, Legal hair has been substituted, which was directed to the registry to be done, your lordship.
Whether notice was issued to them earlier.
Yes, your lordship, they appeared, your lordship.
Appear, none
Yes,
appears
sir.
for the respondent on call. The learned counsel for the appellant submits that the matter is ready for hearing. And as such, it is provided that recessal is the matter for hearing on
January.
in the month of January.
Yes, sir.
23.
Obliged, your lordship.
We have filed a new Wakalat number.
You are for the appellant.
Yes. I'm appearing for Mr. A. Biswas on behalf of A. Biswas.
Pardon me, your good name, please.
S. Paul.
As Paul, learned counsel appearing on behalf of Mr. A. Biswas, learned counsel for the appellant.
Yes.
And Mr. Gogoi, learned counsel for the respondent number.
Lordship, unfortunately, we don't have the file, Lordship.
If I may, my lord, I'm appearing for the previous set of counsels on behalf of Mr. A. Sattar. My lord, my prayer is that the name of Mr. A. Sattar and Mr. Z. Mukit may be struck off from this matter.
Oh, respondent number 4 and 5, State of Assam and Settlement Officer,
Lordship.
right?
Right, Lordship. Right, Lordship.
So the matter is ready for hearing.
No, your counsel.
Why?
Respond number 3.
My lord, one of the respondents has expired, my lord,
Expired.
and the same is reflected in the office note dated 5/11/2024. My lord, the same needs to be substituted.
Office note dated 5/11/2024 indicates that there was a direction for substitution of the legal representative of the respondent number 3, who had already suffered demise, but no step has been taken by the appellant till date. Learned counsel for the appellant is directed to take necessary steps in this regard. Mr.
My lord, G. Imtiaz.
Z.
G. Imtiaz, my lord.
Z. Imtiaz, learned counsel submits that is and the name of Mr. A. Sattar, learned counsel, has to be struck off
And my lord, Mr.
from
Z.
the
Mukit.
cause list, as they have already returned the file to the appellant. Recessal do the needful in this regard.
My lord, and Mr. Z. Mukit. My lord. His
Z?
name Z. Mukit.
Zadmuki. So you have to take a step within 2 weeks. Within 2 weeks from today.
Obliged, your lordship.
List was 2nd December.
2nd December next date.
Timing 20.
None appears for the appellant on call. However, Mr.
BK Sharma.
P.K. Sharma, learned counsel for the respondent present. Mr. Sharma submits that the sole respondent already died in the year.
I do not know exactly.
That's died, and unless the legal representative of the respondent is impleaded here in this case cannot proceed. Accordingly, it is provided that registrar shall issue notice to the appellant. Issue notice to the appellant.
For taking steps. To take steps.
Yes. To take step for impleading the legal representative of the respondent. Sole respondent lists the matter after
9th January.
9th of January.
Item 24.
May it please your lordship. Your lordship, as per office note dated 23/9/2024, AD card has not been received in respect of respondent number 4, your lordship. Your lordship, notices were issued on 25/7/2024. Your lordship, my prayer is that service report may be awaited, your lordship, upon respondent number 4.
Third Miss
P. Bhattapur,
P. Borthakur, learned counsel for the appellant.
lordship.
Appellant. Office note dated 23rd/9/2024 indicates that AD card in respect of respondent number 4 has not yet been received. Accordingly, it is provided that registrar shall list the matter after 2 weeks, awaiting service report upon respondent number 4.
Obliged.
25.
I mean, my lord, the service is complete.
In this IA.
Yes, my lord. My lord,
This IA is for
I is for condemnation of delay of 9 days in
9 days.
yes, my lord. For substituting.
Yes, madam, you are for
For respondent number 1, 2, and 3, lordship.
123. Any objection?
No, lordship.
No objection. Third, Mr. GMT as learned counsel for the appellant.
Yes, my lord.
Applicant stroke appellant. And madam,
MSS thus.
MSS thus learned counsel for the respondent number 1, 2, and 3. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 9 days in filing the connected substitution application seeking implement of the legal heirs of the respondent of the appellant number 1, namely Afzal Hussain, who had passed away on 13/5/2023. What is the ground for delay?
My lord, the applicant is, my lord, a widowed wife, my lord. She was suffering from financial problems, my lord. And she is a resident of Mongoldoy, my lord. Hence, my lord, she could not appear before, my lord, she could not engage a counsel in due time, my lord. Hence, my lord, only a delay of 9 days has occurred.
The learned counsel for the applicant submits that the applicant is the widowed wife of deceased appellant number 1, and because of the financial hardship, she could not engage her counsel in time. and that the
Hmm.
said facts has been reflected in the paragraph number 2 of the application, and that the delay is not intentional, and the same has been explained sufficiently, and therefore it is contended to allow the application. On the other hand, Ms. Thus, learned counsel for the respondent number 1, 2, and 3 submits that she has no objection in the event of condoning delay of 9 days in filing the connected substitution application. Whereas, having heard the submission of learned counsel for both the parties, I have carefully gone to the petition, especially the statement and averment made in the paragraph number 2. And I find that the delay of 9 days has sufficiently been explained here in this case, and therefore this court is inclined to condone delay of 9 days in filing the connected substitution petition. In terms of above, this high stance disposal. Yes, and the other IA?
My lord, that is for substitution
Hmm.
of my lord legal heirs of the deceased appellant number 1. My lord, the names are reflected at page number 4.
Heard Mr. J. Imtiaz, learned counsel for the applicant appellant, and also heard Ms. Z. Das, no, Das, learned counsel for the respondent number 1, 2, and 3. This application under order 22, rule 3, with order 1, rule 10, which in bracket 2 and section 151 of the Code of Civil Procedure, is preferred by the applicants for substitution of legal heirs of appellant number 1, Mohammed Afzal Hussain, who suffered demise on 13/5/2023, leaving behind 4 legal heirs, which is reflected in the paragraph number 2 of the petition as A1, A2, no, 1A, 1B, 1C, and 1D. Any objection? The learned counsel for the respondent submits that she has no objection in impleading the legal heirs of the appellant number 1. In view of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this petition stands allowed. The name of one legal heirs of the appellant number 1, namely Azizun Nessa, which in bracket wife, as A1A, and Asif Raza Hussain son as 1B, and Zakia Salma Safi daughter as 1C, and Anisa Safi, which in bracket daughter as 1D, being pleaded in place of appellant number 1. The counsel for the applicant appellant shall file amended cause title within 1 week.
Yes,
Rest shall list the matter after 1 week.
deeply obliged.
Yes, Lordship. Main case को hearing.
Amended cause title filed for the purpose of the hearing.
26.
Please, your lordship. My lord,
I am for the appellant here, my lord, on 11/9/24, office note says that we have taken steps. And on 21/10/24, records has been received. Report awaited.
Heard Mr. P.K. Rasuduri, learned counsel for the appellant. Office note dated 11/9/2024 indicates that step has been taken upon the respondents, but no report has been received till date. List the matter after 2 weeks awaiting service report upon the respondents.
29. 29.
None appears for the appellant on call, however, Miss
Sahi.
S.
Sahi.
Learned counsel for the respondent present.
Akshit, I am appearing for respondent number 23678112.
2, 6.
23678112.
Office note dated 6/9/2024 indicates that notice issued to the performer respondent number 13 to 14 is awaited. You have for total how many respondents?
7.
7. Therefore, 1, 2,
3678112.
nine, 10. Rest is the matter after 2 weeks awaiting service report upon respondent number 4, 5, 9, 10 and performer respondent number 13 and 14. Registrar also issue reminder to the learned courts below for transmitting the record without further delay.
31.
May I please, Your Lordship? The appeal was dismissed for default, and we have filed an application for restoration of the appeal, Your Lordship. But there is a delay 108 days. So, Your Lordship, what happened on the date when the appeal was dismissed? Inadvertently, Your Lordship, the name of the engaged counsel is not shown in the post list. Annex the post list, Lordship.
Where is that order?
Order is at Lordship in IA 1807. Our order is at page 43, Lordship. appeal was already admitted, Lordship.
Yes, any objection?
Yes, my lord. I have not filed any written objection, but I want to submit for your lordship in here. That, my lord, here in the case, my lord, several advocates were sent during dependency of the case, my lord. Lastly, P. Khatoniar was there, then Pinakshi S. Talukdar was there, then N. Roman was there, then H.C. Sharma, one H.C. Sharma filed Okalatama, my lord. In 2023, my lord. Then I asked him, my lord, Mr. Sharma, that whether I have returned the file to the party. My learned friend did not, actually, there is no Okalatnama of my learned friend in this present case. That is the problem, my lord. That's why the name was not shown.
I have filed Okalatnama, my name has shown in the all this. He filed,
Your name is Mr.
my name is
UB Sharma.
The earlier engaged name of the earlier engaged counsel was Mr. H.C. Sharma. At page 28, Lordship, the acknowledged receipt has been annexed, which shows that Mr. H.C. Sharma filed Okalatnama on 21/9/2023, and the appeal was listed on 5/1/2024. On that day, Lordship, his name was not reflected in the court case. At page 30, Lordship, the relevant page, Lordship, item number 15.
No, Mr. Kolita, now since he has filed Okalatnama, let us proceed for hearing the matter.
My lord, actually, they have to take steps in the case, my lord. There are several defendants died in the meantime.
Acha.
But they have not taken steps. But the case is pending for long, my lord. It is a case of 2013, my lord. Pending for taking steps several days, my lord. That's why the learned court, my lord, dismissed the case. They have not taken steps.
Lordship, actually, learned senior may not go through the brief, but I think there are two miscases are also pending, Lordship, which was also dismissed due to the dismissal of the appeal, Lordship. Those are, Lordship, miscase number 1570/2013, miscase 1940/2014, and IS Civil 3340/2017. One miscase is, Lordship, for setting aside of abatement. Another miscase is for substitution of legal years, and another miscase is there was few delay in filing the application for substitution, and
all these cases were disposed of.
As because all the cases were disposed of along with the appeal, Lordship, as because the appeal was dismissed. Accordingly, on the same day, 5/1/2024, the three miscases are also dismissed. As because the appeal was dismissed, if your Lordship goes through the other miscases.
My only concern, my lord, this is a case of 2013, and we own both the courts, my lord, below. Now, if the appeal is delayed, my lord, they are enjoying the property without any authority of that. That is the main problem, my lord. So, if, my lord, they take steps and the appeal is proceeded, my lord, I don't want that the appeal should be dismissed on my lord, that is all. It should be heard on merit. But if the delay is in such a way, my lord, it will never be disposed of, my lord.
So actually, suit was appeal was admitted, therefore it was sent for usual course for hearing. During that period, some of the respondent died, and accordingly we have filed application. Before their death, how can we file application, Lordship? So after, as and when the respondent died, we have filed accordingly. We have filed the required application, Lordship. There is no delay.
Okay, let us condone the delay of 107 days. Heard Mr. UB Sharma, learned.
My only prayer, my lord, the cost may be imposed so that they will take steps early, my lord.
No, since he has newly been engaged, let him proceed. If we find that he is also caused delay in proceeding, then we will impose cost upon him. Otherwise,
actually, my learned friend's Okalatnama is not in the report. That is the problem.
How my name has
verified,
been
my lord,
shown
on
in
the.
the-
that
No,
is not
his
in the
name
record.
is
My
reflected
name
in the
is
call
reflected
list.
in the cause list. Only, oh, sorry. It's
Secure my-
after filing this application, my lord.
Along with
his
these
name
two
appears.
applications, along with these two applications, I have.
In earlier cases, my lord, his name.
Yeah, I was not in this case, Lordship.
And also heard Mr. Polita, learned senior counsel assisted by Mr. Learned counsel for the respondent number. You have for respondent number?
Actually, my lord, I have prepared for, actually, earlier, all the respondents, my lord, by filing a power of attorney, my lord, on the strength of the power of attorney. Now, they stated that some of the respondents died. They have to take steps, my lord. Earlier, for all the respondents, I appear.
Okay, for all the respondents. This application under section 5 of the Limitation Act is preferred for condonation of delay of 107 days in filing restoration application of RSA number 122 of 2013. Mr. U.B. Sharma, learned counsel for the applicant, submits that the RSA was dismissed by order dated 5/1/2024 as on the date fixed. The applicant remained unrepresented, and in fact, on that day, the name of the counsel was not reflected in the cause list. And that the delay in filing the petition is not intentional, rather it is circumstantial, and therefore it is contended to allow the petition. Mr. Kolita, learned senior counsel for the respondent, submits that he has no objection in the event of condoning the delay, but Mr. Kolita insists that some cost may be imposed upon the upon the applicant. Having heard the submission of learned advocates of both the parties, I have gone to the petition and the documents placed on record, and also there is the order dated 5/1/2024 in RSA 122 of 2013. It appears that the applicant remained continuously absent for 2 days on 8/11/2023, on 29/11/2023, for which this court was placed to dismiss the petition on account of non-prosecution. Having considered the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to condone the delay of 107 days in filing restoration application for restoration of RSN number 122 of 2013. In terms of this IA stands dispose of.
This case 39 also. This case 39 is for restoration.
39 is for restoration. So we'll allow it then.
Lordship, my humble submission along with this appeal, Lordship, the earlier these cases may also be restored, Lordship. Lordship, three miscases pending. One is for setting aside of abatement, one is substitution of legal aid, and one is for delay. Delay in filing the substitution.
Okay, any objection in restoring the miscases? No. Okay, we'll restore it. Next that you have to file then this amended cost title.
If Garnet Senior Council allows, agrees that the substitution may be allowed, then I can amend the post title.
My lord, my concern is only to early hearing of the.
Early hearing, all right, we'll proceed to hear the matter.
Let them take whatever step they want. If Lordship allows, I will be disposed of as earlier. Because this is a very valuable property yet, my lord, in the, is at that, near the Maligaon Bridge, my lord. Every day, my lord, there is enforcement. That is the problem.
That's it. Mr. Sharma,
Yes, Lordship.
the IAs which are to be restored is not mentioned in the cause list. You give the number to the court master.
Yes, Lordship.
Okay. Okay.
Much obliged.
32 and 33.
The time for the appellant. Other side have filed their affidavit in opposition, Your Lordship. They were expressing some urgency for final hearing, entire matter. Today it's for orders. If Your Lordship pleases to take up it for hearing, I am ready, or maybe fixed for hearing.
My lord.
Mm.
My lord, it should be, my lord. It's not hard today. Finalize. My lord, their case, they have no case, my lord. Absolutely false claim. Their deed is false. And they cannot show that they have the land by way of any record, my lord. My lord, I have produced, my lord, some documents by way of affidavit, my lord. If Lordship go through these documents.
This IA is for what purpose?
IA is for stay, Your Lordship.
Acha.
FAO is against the injunction order. I am the plaintiff, Your Lordship. They are the defendants. The defendants prayed for an injunction without any counterclaim or any prayer on their favor, Your Lordship. The injunction was granted in favor of the defendants.
Without counterclaim.
Without counterclaim. Thereafter, we have challenged that injunction order in this FAO. And IA is for stay of that impugned order of injunction, Your Lordship. That is for has to be heard for final.
My lord.
So for granting injunction, they have filed an application.
Yes, Your Lordship.
But they have not filed any counterclaim.
No.
So can injunction be granted without a counterclaim?
Without there being any prayer for permanent injunction. Temporary injunction is granted in their favor, Your Lordship.
Mr. Sigdar?
My lord, there are so many judgments that injunction can be filed without counterclaim. Filing of counterclaim is still open. We can file it, but we feel that counterclaim is not necessary because they have no case. They have no land itself. My lord, their deed is false. They cannot show that they have the land. Initially, on the basis of their false document, there was some petition.
No, maybe you have not made any prayer for permanent injunction.
My lord,
right?
My lord,
and if there was no such prayer, how the this ad interim injunction or temporary injunction can be granted to you?
My lord, our WS has been enclosed in their home. My lord, we simply paid for dismissal of their suit because our condition.
So your prayer was not there.
My lord, we paid for simply dismissal of the suit. My lord. That prayer is there. Dismissal of the suit is there, my lord. So and
no, dismissal of the suit and prayer for permanent injunction are two different things, two different situations.
My lord, that may be, my lord. My lord, we have not prayed for counterclaim, my lord. And the filing of counterclaim is still open, my lord. We have hurriedly filed because they are trying to dispose us. My lord, they have filed title suit challenging our deed and seeking a prayer for permanent injunction, but they have not filed any injunction petition to restrain us. My lord, that indicates that they are never in possession of the land. We are in possession of the land, and their deed that deed is false, that is of 2023. We purchased land in 1994 and we are constructed house and we have shop there.
Now, maybe we are not on the fact. Now we are on the law point.
My lord. My lord, there is judgment that counterclaim can be filed at any stage and that is still open. Issue is not framed. So since issue is not framed,
No, that is open.
That is open, my lord.
Ah.
We can file counterclaim.
That is all right.
But
Without there being any pair for permanent injunction, can I temporarily? cancel the
since we have
gratuity?
not filed any counterclaim, we have simply paid in the WS to dismiss their suit, my lord. That is their that is our WS, my lord. And since we have not filed our counterclaim, that pair could not be is not incorporated. We can incorporate it, my lord, later on. But the present issue is that we have purchased the land in 1994. They have purchased it 2023, and
we are not on the merit of the appeal. Huh? That appeal, that issue is not before us now.
My lord.
It is against the injunction order.
Yes, ma'am. So injunction, temporary injunction we sought for because we are in the possession of the land, my lord. Because of the urgency, because and they are trying to
Have
dispose.
you filed any application before the court?
My lord,
Have
we
you
have
filed
filed
any
injunction petition, my lord. We filed a petition. On our petition, the injunction was granted. That is enclosed in Annex 3 in page 31 of the app. App, my lord.
31.
Yes, my lord, page 31. And our prayer, my lord, our prayer only temporary injunction, restraining them to dispose us, my lord. Since, my lord, we have not filed any counterclaim, permanent injunction, prayer for permanent injunction is not made, my lord. That is a fact, my lord. But fact is that who is in actual possession of the land? We purchased land in 1994. We are in
Without such a pair being made in the petition, can such relief be granted to you?
my lord. My lord, kindly have a look at the, my lord, the impugned order they have challenged, my lord. That order has been discussed, my lord, everything, my lord. That may be looked into, my lord. Whether this order can be challenged is an interlocutory is the order on the miscase, my lord, granting temporary injunction, and that has been discussed, my lord. The principle, golden rule principle has been discussed. We have purchased land in 94. We are possessing there, and we are having shop, and they are trying to dispose us, and therefore we have in a short hurried manner we have filed the injunction petition, and that has been considered, my lord. Everything. And that issue has been raised earlier that we have filed the miscase without counterclaim. The honorable trial court has said that injunction, the counterclaim can be filed at any stage. That issue is still open. So considering the urgency of, my lord, the situation they have created, my lord, they have executed a false deed. They have no land, and on the strength of a false deed, they are trying to dispose us. That under that situation, my lord, the injunction has been granted, my lord. And kindly have a look at, my lord, our documents, my lord, kindly. For a moment, my lord. For a moment. To know the, my lord, prima facie case. Kindly have a look at, my lord, Annexure A, sorry, Annexure B at page 72. It is the deed of in favor of the defendant. My lord. And my lord, the purchaser is, my lord, the present defendant number 1 and 2. Then, my lord, the seller, some persons, Siddiq Hussain, Akhtar Rahman, Bilal Hussain, they are the son of Asmat Ullah Parmani. And there is a boundary also, my lord. My lord, pursuant to this deed, my lord, I have annexed the vernacular also. My lord, pursuant to this, there was a mediation. Kindly have a look at, my lord, the mediation order. Annexure page 86.
No,
That
Mr. Sigdar,
My lord.
so since he is the appellant, he has the right to begin. Let him first argue the matter.
Yes, ma'am. Definitely.
While beginning the matter, the deed that was being referred to, that is actually the subject matter of the suit. We have prayed for cancellation of that deed as well, Your Lordship. Now, coming to the plaint, Your Lordship, the plaint is annexed at page 14 onwards, Your Lordship,
Of your appeal.
of my appeal. Briefly, before going to the entire facts from the plaint, I would like to submit that, Your Lordship, there is an entire plot of land measuring 2 bigha, 2 katha, 5 katha, Your Lordship, that they are claiming that they are the owners of. Out of the 2 bigha, 2 katha, 5 lesa, Your Lordship, at different point of time, different parts were sold by the sellers. Coming to the plaint, Your Lordship, in paragraph number 3, 4, 5, 6, we have shown that during different parts of time, different parts were sold. Subsequently, our vendor, Your Lordship, has purchased a plot of land measuring 2 katha 10 lesa. It is in paragraph 6, Your Lordship. Atwar Rahman, so and so, 2 katha 10 lesa out of the 1 bigha 4 katha 1 lesa that was left behind, has purchased. And thereafter, Your Lordship, we have purchased recently in 2023 that 2 katha 10 lesa, Your Lordship. In paragraph 7, Your Lordship, we have stated that after selling that 2 katha 10 lesa to our vendor, the previous owners, that again Siddiq Hussain, Abul Hussain, Atwar Rahman, Bilal Hussain, all sons of Asmat Ali, alias Haji Asmatullah Pramanik, had jointly sold out the total land measuring 2 bigha 2 katha 5 lesa in favor of the defendants, namely Nurul Islam, so and so, but the delivery of possession of the total land could not be given to the defendants. That is the stated fact in the plaint, Your Lordship. In para 6, our vendor has purchased a portion of 2 katha 10 lesa. After that, in para 7, it is stated, after selling it to the vendor, our vendor, the entire plot of land was sold again to the defendants, Your Lordship. However, without delivering the possession. Thereafter, in para 8, that since the plot of land measuring 3 katha 4 lesa and out of the land measuring 2 katha 10 lesa has already sold to Abdul Hussain and Atwar Rahman, both sons of Haji Asmatullah Pramanik, out of the total land measuring 2 bigha 5 katha. So 2 number of separate registered sale deeds in favor of so and so. So the transfer of the plot of land measuring 1 bigha 1 katha 11 lesa remained under dag number so and so. So subsequent transfer of the plot of land measuring 2 bigha 2 katha 5 lesa by Siddiq Hussain, Abul Hussain, Atwar Rahman, Bilal Hussain, all sons of so and so, in favor of the defendants through registered sale deed number 2306 of dated 8/9/1994 is illegal, void and inoperative and is liable to be cancelled. Subsequently, Your Lordship, thereafter we have stated that we came to know about this when we went for mutation about this subsequent sale deed, and as such we filed this title suit for confirming our possession over the suit land, which is 2 katha 10 lesa, and cancellation of their sale deed, which is for the entire plot of land that is purchased after our vendors have purchased a portion out of that. This is the situation of the plaint, Your Lordship. They have filed a WS, Your Lordship, against this, which is at page 21, annexure 2. In WS, also, Your Lordship, as I have already pointed out, they have not filed any counterclaim challenging the registered sale deed by which the plaintiffs had purchased the plot of land. That was also a registered sale deed, Your Lordship. They have also not challenged the cancellation. They have also not prayed for cancellation of my vendor's registered sale deed, Your Lordship. Neither my registered sale deed from my vendor nor my vendor's registered sale deed from the original owners. Simply, they have filed a WS stating that they have purchased through a registered sale deed, so they are the owners. Now, Your Lordship, in paragraph, in their WS, Your Lordship, in paragraph 30, in paragraph 7 of the plaint, as I have pointed out, we have stated that they have not got the possession of the suit land.
in para 7 of the plaint.
Mm.
In para 13, they have replied against the para 7, Your Lordship, if I may read.
Mm.
In reply to para 7, answering defendants state that Siddiq Hussain so and so are all sons of Asmat Ali. Siddiq Hussain so being the pattadar and possessor jointly sold 2 bigha 2 katha 5 lessa covered by the Agn number so in favor of the answering defendant and delivered possession within the boundary so. After getting delivery of possession of the purchased land measuring 2 bigha 2 katha 5 lessa, the defendants constructed their residential house in the southern side of the purchased land. And in the northeastern corner, defendant has constructed 2 shop house wherein their son and nephew of the defendants, namely Rizaul Korim and Inamul Hassan, running their business under the name and style of Arzu Enterprise and Hassan Medical Stores. This is the bone of contention, Your Lordship. They are stating that they have their nephew and son are running 2 shops in the suit land. After filing of this WS, they have filed this injunction petition, Your Lordship, which is at Annexure 3, page 31. Here in paragraph 2, they have stated about those 2 shop rooms, Your Lordship. Arzu Enterprise and Hassan Medical Stores, run by their son and nephew. Son and nephew are not parties to the suit. If we have at all registered, they are claiming that the plaintiffs are resisting them from running the shop room in the scheduled premises. As such, they require temporary injunction restraining us from resisting them. They have stated in paragraph 2 of that injunction petition that Arzu Enterprise and Hassan Medical are in the northwestern part of the purchased land, and the remaining part is a low-use land which they are using for cultivation of fish and other things. And it is claimed in this petition that we are resisting them from running the shop room in the premises. As such, they require injunction. We have filed our objection to that as well. In the learned court below, they have not produced any document as to how this Arzu Enterprise or Hassan Medicals are established. However, in this appeal, they have filed an affidavit in opposition, which showed the trade license of these 2. We may come to that as well, Your Lordship. The affidavit filed by them, Your Lordship. In page 82, 83 is copy of license issued to Rizaul Karim, and 82 and 83, Your Lordship. Though I am referring to these 2 documents, Your Lordship, but this one not before the learned court below. These are filed here in this affidavit. 82 and 83, they have stated that Rizaul Karim has a trade license for running Arju Enterprise. And page 85, they have annexed. This is Hassan Drugs Distributor, Your Lordship, page 85. In page 85 itself, Your Lordship, if I may read, MS Hassan Drug Distributor is licensed to sell, stock, exhibit, sell, distribute, wholesale on the premises situated at care of Jamaluddin Village, Longla, near Longla High School at Kolgachia, Borpeta District, Your Lordship. They have produced a document to show a license of Borpeta District, whereas the suit land is in Bongaigaon District, Your Lordship. These documents, though were not before the learned court below, while deciding the injunction, but I'm just pointing out, here they have produced 2 trade licenses at a belated stage, that too of a different plot of land. Be that as it may, Your Lordship, depending on this injunction petition, against this injunction petition, we have filed written objection as well, Your Lordship, which is at Annexure 4, page 39. Denying that we are stating specifically that we are possessing a plot of land measuring 2 katha 10 lessa only, and not the entire 2 bigha 2 katha 5 lessa as they are claiming. So our plot of land is a smaller plot of land, not the entire 2 bigha 2 katha 5 lessa, and we are enjoying possession over our plot of land, and we are not disturbing their peaceful possession or anything over that 2 katha 10 lessa of land, Your Lordship. So even after filing this objection, Your Lordship, now coming to the impugned order, which is at annexure 5, page 44. The learned court has assessed prima facie case, balance of convenience, and also irreparable loss. Now, prima facie case, Your Lordship, it is understandable that there is a claim and there is some denial, not counterclaim by the other party. There may be a prima facie case in this matter, Your Lordship. They have also stated about Hassan Medical and Arju Enterprise, Your Lordship, but there were no documents before the court below. Documents are produced here. And it was also claimed that Hassan Medical and Arju Enterprise is run by the son of the plaintiff and nephew of the plaintiff. There is no complaint from them as well as to whether we have been disturbing their peaceful possession or their operation of the shops as alleged. And there is no occasion to do so because they are not the parties. Had there been any disturbance on our part towards them, there could have been a separate suit or otherwise by the owner or proprietor of Hassan Medicals and Arju Enterprise. Now coming to balance of convenience at page 49, internal page 6. If I may read, Your Lordship. Now, the petitioner, as discussed above, has made out a prima facie case. The opposite party side has contended in their written statement that so and so had jointly sold a plot of land measuring 2 bigha 2 kata 5 lesa under DAG number 372 and patta number so and so in favor of the petitioner's defendants, namely Nurul Islam, Fazeda Khatun, by registered sale deed number 2306/1994. But the delivery of possession of the total plot of land could not be given to the petitioners. It is also stated, since the plot of land measuring 3 kata 4 lesa and the plot of land measuring 2 kata 10 lesa out of DAG number so and so were already sold to so and so. It is also stated that means, Your Lordship, the possession over that portion of land could not be given to them because out of that 2 kata 10 lesa was already sold to my purchase vendor, Your Lordship. Thereafter, coming to the next paragraph, next page, Your Lordship, in the first paragraph itself, fourth line, Your Lordship, what we have prayed. So the subsequent transfer of plot of land measuring 2 bigha 2 kata 5 lesa by the Siddiq Hussain, Abul Hussain, Atwar Rahman in favor of the petitioner defendant through registered sale deed number so and so is illegal, void, and is liable to be cancelled. That was our prayer in the plaint, Your Lordship. We have prayed for cancellation. Now coming to the last paragraph of page 50, Your Lordship. Now, if no temporary injunction is granted and the opposite parties, their mains agents are allowed to dispossess, if there has been a threat by the plaintiffs towards the defendants to dispossess, they could easily file a counterclaim or at least another case, Your Lordship. There is nothing. The agents are allowed to dispossess the petitioner defendants from Schedule B land and are allowed to obstruct the petitioners from running their business in the shop house situated in Schedule B land, then it will prove a great loss to the petitioners on being deprived from their home and earning of their livelihoods, leading to irreparable loss, while on the other hand, granting such temporary injunction till disposal of the main suit will not cause any harm to the other side. So, the second golden principle of granting temporary injunction, that of balance of convenience, stands in favor of the petitioners. Here, Your Lordship, the learned court below has said that if temporary injunction is not granted to the opposite parties, they may lose their plot of land and their livelihood. The livelihood that they are alleging, the shop rooms, two alleged shop rooms, Your Lordship, are admittedly of their nephew and son. And the land they are claiming is a plot of land measuring 2 bigha 2 kata 5 lesa, whereas the plaintiff in the plaint has prayed for confirmation of possession of 2 kata and 10 lesas of land only, Your Lordship, not the entire 2 bigha 2 kata 5 lesa. However, we have prayed for cancellation of their sale deed, which is for the entire plot of land. Now, Lordship, another thing in this balance of convenience, Your Lordship, Here they have, the court has also said, if the total plot of land is if no temporary injunction is granted to the opposite party, their main agents and allowed to dispose of the petitioner defendants from the Schedule B land and are allowed to obstruct the petitioners from running their business. As such, your lordship, under by this temporary injunction, if I am restrained, say I am obstructing, say for example, if I am not obstructing as well, the court has assumed that I am obstructing them from running their business. So this temporary injunction by which I am directed not to obstruct them is a mandatory injunction in a way, your lordship, that will allow them to operate a shop room which they have alleged to be there without showing any document or anything before the lower court. And they have claimed that we have a shop room, let us run this. Where is the shop room? They have not produced anything before the court below. And whether that shop room is on our plot of land measuring 2 Katha 10 Lesa or somewhere else is also not indicated, your lordship. Now coming to irreparable loss, your lordship. Irreparable loss, your lordship, has already seen. If the suit is dismissed tomorrow, they will not have their independent claim. They will not stand on their own foot. If our suit is dismissed, it is dismissed. They will not gain possession over our plot of land because they have no prayer in that regard. Whereas if our suit is decreed in future, your lordship, then this temporary injunction will be causing irreparable loss to us, your lordship. Because if it is decreed tomorrow in our favor, that plot of land and their sale deed is cancelled, your lordship, then our right title and interest over our plot of land will be made concrete. Whereas if it is dismissed, there is nothing on their part. Now coming after this, your lordship, something else happened. This injunction was granted. We preferred this FAO and this IA for stay. This FAO was admitted. Immediately what they have done, lordship, just to show the conduct of the parties, immediately they have filed a petition praying for police assistance, your lordship, which we have challenged in this CRP, connected CRP, your lordship. They have not gone for the regular course whereby they will allege that injunction has been violated and I need to be punished for the injunction. Nothing of that sort. Under 151 of CPC, your lordship, they have prayed that injunction was granted. They have not gone under Order 39 Rule 2A, your lordship. They have gone directly under 151 and said we need police assistance for opening our shop room and for using this plot of land, your lordship. The court below has also granted that without there being any assertion or any inquiry as to whether we have actually violated or not. We have objected that we have not violated any injunction. We are peacefully possessing our plot of land. And on the strength of that order of the court below, your lordship, they have taken the assistance of police and police has been started disturbing us from our small plot of land measuring 2 Katha 10 Lesa. Then we have challenged it by filing this connected CRP as well. And this IA it is tagged with the FAO, your lordship. Now, I would like to rely on few judgments as well.
On which point?
One, on the point, your lordship, that temporary injunction cannot be granted if there is no prayer for permanent injunction. On that as well.
Okay.
Okay, I'll just get a printout. I don't have the copy with me now. I'll just, after they conclude, I'll just give the citation and everything else. So our High Court's judgment is there. And another thing, your lordship, they have filed this affidavit in opposition, just to respond to that as well. I have referred to one of the documents whereby the address mentioned in the trade license that they have annexed with the affidavit, Your Lordship, it is of some other place. And the trade license that they have shown, one issued by Panchayat and another this drug license, Your Lordship, nowhere state the schedule or land or area on which these shop rooms are located. Our submission is that on our plot of land, there is no shop room of the defendants, their son or nephew whatsoever. All these are false claims, Your Lordship. Secondly, Your Lordship, they have also annexed Jamabandi, Your Lordship, a Jamabandi which shows that it is at page 91. 91 is the translated copy. Page 98 onwards is the photocopy. By this Jamabandi, they are trying to show that presently the name of the plaintiffs have been struck off from the revenue records. Page 98 onwards. On page 98 itself, if we come to the Mantobya section, Your Lordship, the remarks column, the second remarks, Your Lordship, it clearly states that Chokro Bikoyar Iman Tarikhor Namjari Iman number so and so mote Dui Kotha 10 Lesa Mati Horid Dokhol Sutre Bilal Hussein or Tholot Abdul Alim Pita so and so Aru Jil Hussein Pita so and so Namat Namjari Kora Hola. That means the plaintiff's names were recorded as per this mutation, Your Lordship. However, subsequently, the name of all the plaintiffs are deleted, Your Lordship. Coming to page 100.
This 99.
Page 99, from page 99 itself. From the, say for example, the third last, Your Lordship. Shaidul Islam dated so and so. Abdul Alimor Nam Korton Kora Hol, Natmondol Protibedan Swa Hol. So why this name was deleted and how our name was deleted is not before this court and is nowhere placed. Deletion of the name of the plaintiff. There is a sale deed in name of the plaintiff, and on the basis of the sale deed, the mutation was done. Subsequently, this mutation was cancelled, being the Protibedan of Latmandal. This cannot be a ground to show that there is no land in the name of the plaintiff. That is challengeable, and I will take instruction. I think that has been challenged by the plaintiff because initially there is a mutation on the strength of his registered sale deed. However, seeing the Protibedan of the Latmandal, the name of the plaintiff was deleted from the revenue records. This is also strange, Your Lordship.
This correction 11/7/11.
So briefly, this was a submission. I will just give the details of the quotation.
Yes, Mr. Singh.
My lord, I will start where my friend has
Left.
left, my lord. My lord, in my affidavit in opposition, documents which has been just now relied upon by my friends, the land documents, my lord, it starts from page 86. Sorry, my lord, it's page 91. Page 91. Their mutation, my lord. Annexer is page 91. The translated
that mutation was cancelled later on.
Yes, my lord. My lord, they have challenged on the strength of a sale deed and where land has been shown that their sale deed also we have annexed, my lord. My lord, I want to refer their sale deed first, my lord. The sale deed to put a sale. That is at page 103. 103, the vernacular is of at page 105. My lord, it is of 4/10/2023. Their sale deed. Lordship may kindly have a look at the vernacular. There is a mistake in translation in English, my lord. It is date is wrongly mentioned as 4/10/2013. In fact, it is 4/10/2023 as indicated in the vernacular at page 105. And their sale deed, my lord, that indicates the schedule, the land in tag number 1190 and patta number 785. Covered in the village. In the village season gram revenue of Simlabari, part 1. Well, this is the description of the schedule that their land is covered by tag number 1190, patta number 785. My lord, kindly have a look, my lord. Now the Jawundi, their Jawundi, my lord, at page 91. Page 91, my lord. The land in tag number, patta number is shown in, my lord, in the extreme left column, 785, and the tag number in column number 4, under column number 4, 1190. My lord, the area of land 000. They have no land in that agglomerated whereby they have purchased the land. That sale deed is thereby it is established that the sale deed is totally false, my lord. They have no land in that tag number and patta number, and therefore, my lord, although initially their name is recorded as shown by my friend in page 92, my lord. Starts from page 91. As per 92, my lord, second paragraph, as per mutation order dated so and so, the circle officer took at a 10 lesser land. Tag number 1190 has been mutated in the name of Abdul Alim, son of late Bilal Hussain, and Jil Hussain, son of late Siddiq Hussain, Khairul Islam, son of late Siddiq Hussain, Saiful Islam, son of late Hussain, Abul Hussain, Shoidul Islam, son of late Abul Hussain, and Nurul Amin, son of late Atur Rahman, Abu Bakr Siddiq, son of late so-and-so, and Sanidul Islam have been recorded in place of Bilal Hussain. That their mutation, my lord, the vendor is Bilal Hussain. Subsequently, lordship, my lord, at page 93, the deletion has been started. Deletion has been started in third paragraph, note. There is a star mark, note, Latmandal, Saidul Islam, dated 2023, 11/7. Name of Abdul Alim has been deleted. The report of, as per seen the report of the Latmandal, order issued by making correction, circle officer. Then, my lord, this correction is, my lord, 711 and 811. Then, my lord, again the name of Abdul Alim has been deleted by the subsequent order that was done on 7/11.
Okay, all right. Their names are deleted.
Deleted. All their names have been deleted. This deletion is done prior to the filing of the suit, my lord. That filing, prior to the filing, they have not taken about that fact, my lord. Thereby, we want to say that their suit is infructuous. They have no suit at all, no case at all for challenging our sale deed, my lord. Our sale deed,
Mr. Sigdar,
my lord.
These notes of cancellation of their deletion of their name, relating to deletion of their name, no ground is mentioned.
My lord.
Why their names were deleted?
There was inquiry. There is some separate order. It is only, my lord, correction. There may be some separate order on the.
Can you produce that order?
That is their land, my lord. They want to. They should show that they have the land. We have shown some documents that they have no land.
No. They have already stated that they have their land there. Your contention is that they have no land there. So it is your duty to establish that they have no land there.
My lord, my lord, so Jamamundi, this Jamamundi, so that they have no land.
why their names are
My lord,
deleted from
My
the?
lord, Jamamundi, when Jamamundi record shows some fact, my lord, unless they dispute, unless they prove it otherwise, this Jamamundi record cannot be disputed, my lord. They should dispute, my lord. They should show that this is not correct. That is the law of the land regulation, my lord, regulation 41(2), my lord. That unless and otherwise, my lord, the record entry made in this the record is disproved, that should be presumed to be correct, my lord.
No,
That is the law.
okay, we will presume it, but we want to know what is the reason why their names are deleted.
My lord, their land, my lord, purchasing the land is a totally false. My lord, kindly show, my lord.
Well,
The
what is the inquiry report?
inquiry report that may be fault from the authority, my lord. Circle officer, they have not made party, my lord. And my lord, one thing, my lord, another important thing, my lord. If person
You obtain a certificate copy of that report, inquiry report.
My lord, we have obtained the certificate copy of the
Inquiry report.
My lord, Jamamundi only. Jamamundi, my lord, and
No.
they have their vendor in the meantime died. They purchased land from Bilal Hussain. He has died, and their legal heirs also not made party. That is another fact, my lord. And kindly, my lord, see, my lord, their sale deed.
Mr. Sikdar,
My lord.
if you produce the report, inquiry report, it will be helpful for the court in deciding the matter.
My lord, we may try. We can make an effort.
What is the inquiry report? Why their names are deleted?
My lord.
And it will substantiate your submission also.
My lord. My lord.
So you obtain a certified copy of the inquiry report?
My lord, we'll try, my lord.
Let us fix a short date then.
My lord, for collection of report, it will
After
take
1 week?
some time, 1 week time. My lord, at least 15 days, my lord. It will
15 days.
take time, my lord. Lordship, a list after 10 days we will try, and if some difficulty, my lord, we will have to take further examination.
Okay. Heard Mr. Mukherjee, learned counsel for the appellant, and Mr. Sikdar, learned counsel for the respondent. Heard in part, place the matter on COVID.
Lordship, after 10 days. 27. 27.
27.
27.
So,
burden should also be given to them also, my lord. They have to collect their status of the land, my lord.
no, Mr. Sikdar, assertion is made by you.
We have
It
produced
is
the,
your duty to establish the same.
we have produced the registered sale deed otherwise, your lordship. There is a sale deed. They have not challenged that at all.
So, my lord, there are so many judgments of the Supreme Court that unless the entry in the
No, that's all right. There is no dispute about it. Law is there, judgments are there. Even then, we want to see the reason why it was cancelled. So as to enable Mr. Sikdar to produce the inquiry report based on which the names of the present appellants were deleted from the copy of Jamabandi or from the revenue record. Revenue record.
proper word will be Jamamundi, my lord.
Jamabandi.
Jamamundi.
Okay, Jamabandi.
28.
Huh?
28 November.
8 November.
28.
20. Develop.
Item 34.
The RSA, connected RSA of 22 of 2023. So, my lord, I file a miss case, my lord, this IA civil 2915 of 2024 for early hearing of the case. So, my lord, why this petition is filed, my lord, your lordship, I will straightforward draw your lordship's attention to page 3, paragraph 4. Here, what happened, my lord? The land involved in the RSA. There is an appeal pending, my lord, before the deputy commissioner regarding mutation, etc. And another thing is this, my lord, in the original decree was passed. In the original decree, my lord, the
Okay, Mr. Say,
my lord,
we will hear you. We will allow your petition.
maximum.
So when can it be fixed?
My lord, it is November, my lord.
No, November not possible.
In December, my lord. In December.
December in the third week? Third week of
My
December.
lord, holiday will start from 22, my lord.
Prior to that day?
My lord, before that, my lord, 16
December.
16, 17.
17 December.
17
December.
December.
Heard Mr. MSA, Learned Counsel for the applicant. This application under section 151 of the Code of Civil Procedure is preferred by the applicant for early hearing of RSA number 22 of 2022. Having heard the submission of Mr. Sheikh, Learned Counsel for the petitioner, the applicant, and also considering the statement and environment made in the petition, especially in paragraph number 4, this court is inclined to allow this petition. It is provided that rest shall list the matter on
17/12.
17/12.
24.
I stands closed.
But in RSA, order will be necessary. IA is disposed of. In connected RSA, order is to be recorded that as in pursuance of IA matter may be listed. Because IA is
No, on the basis of IA, the registry will list the RSA before this court. RSA is not necessary.
I point out, my lord, whether in the RSA that order is necessary.
No, in RSA it is not necessary. IA.
35 and 36.
May I please, Lordship, as per office note dated 5/11/24, neither AD card nor answer notice on response number 1 and 2. So I pray service may be awaited on 1 and 2.
1 and 2.
So far, my lord, 3 to 6 are concerned. In the IA, we have not made them party member. So their presence is not required.
Their performer respondent.
Performer respondent.
Third, Mr.
G. Bhardas.
G. Bhardas, Learned Counsel for the applicant. Mr. Bhardas submits that as per office note dated 5/11/2024, neither AD card, no, service report in respect of respondent number 1 and 2 are awaited. And Mr. Bhardas submits that the matter may be listed after 2 weeks.
2 weeks.
Awaiting service report upon respondent number 1 and 2. Further, Mr. Bhardas submits that service upon respondent number 3, 4, 5, 6 are not required, as they have not been made party in the
Present IA.
present IA. Okay. Rest shall list the matter after 2 weeks.
37.
This case was mentioned because on an earlier occasion, RSA was admitted, madam. But as I could not give the title execution case number, so the execution proceeding was not stayed. So Lordship has asked me to obtain the instruction and make a mention. That is why the case was listed today, madam. So I have obtained the execution case number, madam. Title execution case number 33 of 2024.
You obtain any certified copy of that order?
No, my lord, over telephone, my lord, because party is that my lord Borbeta. So So I obtained the telephonic instruction, my lord, and last date was fixed on 30th of October.
When it was filed?
My lord, it was filed after filing of this RSA, my lord.
Then how can you submit on the other day that execution case has been filed?
My lord,
If they
RSA
have
was
filed the execution case after filing of this RSA,
yes.
on the other day, how can you submit that execution case has been filed?
RSA was filed on, my lord, lordship will find that it was September, my lord. It was filed in September. And case was, my lord, moved on.
Have you received any
21st.
notice in execution case?
Notice, my lord, I was told that that revenue person came to the, my lord, that scheduled land. On that day also, I
If
submitted.
that being so, they have filed the execution case.
My lord.
Have you not received the notice till now?
Maybe, my lord, because
You do one thing.
my lord.
We'll fix a short date. In the meantime, you obtain either you file one affidavit enclosing that notice you have received or the certificate copy of that execution case.
So the field and lordships some observation because otherwise, my lord, it will be, my lord, very difficult, my lord.
No, immediately they cannot execute the warrant, execute the writ.
So
Unless notice is served upon you, unless objection is filed by you. We will stay. There is no
objection, my lord,
problem.
if it is filed, perhaps, my lord, as per if I am correct.
You
my lord.
produce any
If it is-
document or notice, even the notice will serve the purpose. We are ready to stay the matter.
I know, my lord, but I have provided the execution case number, that is.
You ask them to provide the copy of notice they have received from the court or the execution case. And if they receive notice, then definitely notice will be accompanied by the
My lord,
Yes.
if I am, my lord, correct, but if the execution case filed within 2 years, my lord, notice may not be necessary also. That is also one aspect, my lord.
You
because-
obtain certificate copy then. Inquire from the court. Would you follow my
Yes,
instruction?
I follow, but till then I am, my lord, apprehending that.
No,
that something is
immediately it
but-
cannot be. Immediately it cannot be. Immediately it cannot be. So next Wednesday, even if you can produce that this by WhatsApp also, you can obtain the notice if they received it. You can produce that before this court. Some document is necessary.
Perhaps I need not to file any affidavit.
File an affidavit.
Because my person is, my lord, he is, my lord, actually bedridden, the appellant. On that day, he somehow came to me.
Okay, that liberty is given to you. You show me the
My lord.
WhatsApp also.
My lord.
Okay, we'll see. Heard Mr. Kolita, learned counsel for the applicant, list the matter on Wednesday so as to enable Mr. Kolita to produce any document in respect of initiation of execution proceeding before the learned court below by the respondents.
On 13th. Item 38.
Please, Your Lordship. Lordship, this is for substitution of the respondent number 3, Lordship. There is a delay of 400 days in filing the same, Lordship.
Let notice go.
Lordship.
Heard Miss,
As to the Lordship.
learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is preferred by the applicants for condonation of delay of 400 days in preferring substitution petition. There is no, let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process, which I know from today. List after 4 weeks.
Obliged, Lordship.
Pending it as a 2 PM.
Get out of there.
Second,
Okay.
that a fixed as a 2 PM, limited.
Ms. Kumar, prays for third accommodation and further submits that thereafter she will not ask for any accommodation.
Okay.
Thus assurance, prayer of Ms. Kumar is allowed. List the matter after 2 weeks.
2 weeks.
That may be fixed then.
2 weeks, 7, 14, 20, 29th.
29
29 November.
Highly obliged.
Timing item 41.
No, 14.
I'm sorry, timing item 14. Timing item 14. After some time.
Okay.
Timing item 43.
I'm sorry, my lord.
Yes.
I have submitted the corrected memo of appeal. Basically, to be corrected memo of appeal.
Yes.
Philosophically, here only fact is this, my lord. My father have a plot of land even in 5-6 bighas. And
So let me clarify one point. There may be some confusion regarding subsection 3 to section 100. Regarding this incorporation of substantial question of law in the memo of appeal. So there is a judgment of Supreme Court in Santosh Hazare versus Purushottam Tiwari, deceased by Ehlers, reported in 2001 3 SCC 179. There Supreme Court stated that appellant to precisely state in the memorandum of appeal the substantial question of law involved in the appeal. So you have to state it in the memo of appeal itself, not in a separate or loose sheet.
now I am giving.
Oh.
I have submitted. Earlier when this matter come, actually, and that time I filed along with the ground and substantial question of law. The lordship asked me to file the amend the memo. I amend it. It is item 43. Item 43.
So what are the substantial question of law here?
Now, before that, I clarify one. If you lost permit me, that this father of the appellants have a lot of land within 6 bighas something. He has 4 sons and some daughters. So according to Mohammedan law, the 4 sons will get 4 bighas, 4 kata 9 litres of land each. The dividend number 1 here, his share is 4 kata 9 litres. All the brothers are jointly possessing the said land. But something what happened, out of 4 kata 9 litres, he gave 2 katas land to one Abid Ali. Now he remained 2 kata 9 litres. Now subsequently when the land was a annual patta, he applied for conversion of the Medi patta regarding 2 bigha something malo. Subsequently his name has been land has converted to Medi patta by showing his name without considering the name of the other 3 brothers. Then, my lord, the plaintiff filed a suit alleging that the Abid Ali sold 1 bigha of land to the plaintiff. My question is this: well, he cannot sell beyond his share. Number 1, he cannot sell beyond his share. Then the filed a suit, the plaintiff only implemented the dividend number 1 as a dividend in the suit. Then, my lord, other 3 brothers also jointly come, file resignation and file also counter claim.
they raised a question that after some years they came to learn they have got a registered sale deed and obtained it fraudulently. So thereafter they filed a counterclaim saying that the deed obtained by the plaintiff is fraudulent one. And now second question is whether one brother can sell 1 acre of land beyond his share. This is only now the Buddha court will did not consider it, and moreover the exhibit A, the Jawan where all the name of the brothers were appeared also not considered by the by Buddha court below. Now after purchase by the plaintiff, there his name has been entered. Definitive name only one entered after conversion of the land. This is the matter. Now, 2 appeal has been filed against the judgment, since judgment, one for dismissal of counterclaim, one for this decree of the suit. That is why I filed 2 appeal here. The only question is whether the one brother can sell the land of excess of beyond his share value. He cannot do it, and that matter has not been considered by the Board of Court. Now, moreover, my lord, at least this has been executed very long back, but position is in my favor, my lord. He is not taken position, which clearly goes to say that this has been fraudulently obtained. The definitive one clearly stated in counterclaim as a reason that he has not executed any sale deed in his favor. Deed was deed number 947 2012.
So the land was annual patta land.
Originally annual patta land of his father, their father.
So what was the total?
6 bigger. Total land is, my lord, 6 bigger.
So what is the
5 bigger, 4 bigger, 10 lesser. 5 bigger, 4 bigger, 10 lesser.
What is
jointly
the,
possessing.
what is the substantial question of law involved herein?
5, says 5, my lord. But that point I not says 5, my lord. Purposity is there, where is purposity? But did not consider the evidence on record, my lord, properly, my lord.
No, only on the ground of perversity we cannot
not purposity only. Not purposity only. The deed has been obtained fraudulently. Number 2, my lord, whether the one brother.
But whether the deed is obtained fraudulently or legally, that is a question of fact.
That is to be considered.
Can it be a substantial question of law?
That is to be considered after clearly discussing the evidence on record, my lord. But no issue has been framed in the counterclaim in that point. In the suit, the issue has been framed, but in the counterclaim, no such issue has been framed. We claim the deed is to be set aside of the deed. D to them, my lord. D. The land is on our positions. They say that they passed the land 2012. How, my lord, without delivery of position? And we are still in position, my lord. But officially they did it.
Mr. Ahmed,
my lord.
Supreme Court in the case of Madhavan Nayar versus Bhaskar Pillai, 2005 10 SCC, page number 553. 2005 10 SCC, page number 553. There stated that even if the first appellate court commits an error in recording a finding of fact, that itself will not be a ground for High Court to upset the same.
There are other that when I bring to the next case, that the Honorable Supreme Court held that it is not a absolute rule that the High Court has not power to regulate the evidence in record and alter the findings of the appellate court.
What is
There
the
is no-
judgment?
Yes, I. Paragraph 13 onwards, my lord, there is the observation that there is no hard and fast rule that the High Court has no power to re-evaluate the evidence on record, even concurrent finding, my lord. High Court has the power in the case wise, my lord. And 2018 SSC 302. Yes, sir.
Mr. Ahmed,
My lord.
this paragraph number 13.2, there Supreme Court has referred to a decision of Ramathal versus Maruthal. That decision was of the year 2019. 2018 18 SSC 303. But the judgment I have referred to is of 2005 10 SCC.
Yes.
So
10 SCC.
which one will prevail?
Later on, I given the 2018 judgment. Madam. Later on.
No. Now it tell me which judgment will prevail. Earlier one or the last one?
Last one.
Last one.
Okay. Last one.
Have you,
2018 judgment I given.
Mr. Ahmed, there is a judgment of Supreme Court dealing with this doctrine of precedent. That judgment is a New India Assurance Company Limited versus Pranay Sethi. Constitutional bench stated that the earlier one will prevail, not the last one.
But
Hmm?
but your lordship kindly see the 2018 judgment passed by the Honorable Supreme Court.
Hmm.
We cannot dilute it, my lord. So
Hmm.
far as I am concerned, we cannot.
That's all right. Then you have to go by the doctrine of precedent.
My lord. My lord, therefore,
Hmm.
the law cited rendered in 2018 judgment, my lord,
Hmm.
there is a clear finding is there.
Hmm.
Yes, this High Court is not a powerless, my lord. The High Court has the power to re-evaluate the entire evidence and record. If it is found the both the court will has concurrently,
Hmm.
so this court has the power. And those judgments also, yeah, that is not, there is no discussion that this High Court has not not the authority. In exceptional cases, in case wise, this Honorable High Court has the power to regulate the evidence and records. And if a lordship, in that case, a lordship see the evidence, one part of the evidence, clear that completely non-application of mind, my lord, by both the court below. Amin Commission report says, in that case, where next case, Amin Commission report says the plaintiff of possessing excess land. But Amin Commission report has been rejected. But maybe rejected, but that was a part of one evidence. He clearly, our case was also there, my lord, that our Switzerland is not part of the Switzerland. It is extra of the Switzerland. But they, by taking advantage, they go by my land. That matter was stated in lordship fixed at 2. So anyhow, my lord, madam, examine, my lord.
No. First, you have to satisfy the court whether substantial question of law is involved here or not.
Yes.
Because in this judgment, Narayanan Rajendran and another versus Lakshmi Sorojini and another others, civil appeal number 742 of 2001. Supreme Court has cautioned the High Court not to admit the second appeal in a routine manner.
2001.
Civil appeal number 742 of 2001. And there lot of case laws has been discussed by the Supreme Court in respect of this second appeal.
But your lordship, next judgment I refer 2018, lordship can see paragraph 14, my lord. Because even the section 103,
this judgment is of two judgments. Yes. And this judgment cannot
override
overrule the earlier judgment.
No, I am not on that. In that case, it is a particularly held that discuss about the section 103. Section 103, can you see? Section 100 and 103 Buddha discuss in that case. Well, 103, my lord. The power of High Court to determine issue of facts. In any second appeal, the High Court may, if the evidence on the court is sufficient, determine any issue necessary for the disposal of the appeal. If you lordship kindly go through the evidence and record, it is crystal clear that both the court will has overlooked the summary. And whether a brother can sell one bigger land axis of his, my lord, although there are 4 brothers are there, they are jointly possessing the land, my lord. Whether one brother can sell the axis, land in axis, he cannot do it. But that question has not been decided. Whether the division number 1 can sell 1 big of land, although he has shared is only 4 kata 9 lesa. And after
both the appeal relates to the same matter.
Both the same matter. One dismissal of counterclaim, one suit was degree. Appeal judgment was passed.
Mr. Sharma, you are in this appeal?
No, no, in that.
Not in this two appeal.
It is not fresh, my lord. Fresh.
We'll fix the matter for further hearing.
Okay.
In a routine manner, we'll not admit the second appeal.
As a lawsuit.
Heard Mr.
After
J. Amel, learned counsel for the appellant.
after 2 weeks, I will.
Not 2 weeks, after 1 week. List the matter on Kobe
On 18th November.
for further hearing on the point of substantial question of law involved in this appeal.
Coming item 44.
Same order.
Timing item 41, bail hearing.
May I please, your lordship? 483 application, lordship. Petitioner was elected on 12/7/2021. Today is about 3 years, 3 months, about 4 months. In this case, final complaint was filed. Then the lordship charge starts paid on 21/2/2023.
This is second application.
This is second application.
So what is the ground for filing this second application?
Second application, we filed lordship after framing of charge. Lordship, only 2 number of witness till today examined.
How many witnesses were cited?
That is the main problem, lordship. I did not find in lower court record as well as in this record, lordship, the list of witnesses.
Then from where the court below is summoning the witnesses?
I have no idea, lordship. It is.
Are you not defending the accused before the trial court?
If there is nothing, I'm not conducting the trial. That is why I have no idea.
Okay.
Lordship, in this case, I've tried to find out the list of witness, lordship, and when I applied for certified copy, at that time my junior colleagues charged the record. In that record, it is not on today also, we searched the record of this honorable court. In this record also, the list of witnesses is not there.
Citation কেইটা লিখি ৰাখি থৈ দিবি। নাই এইটো তলৰটো ইয়াৰ আমাৰ কোৰ্টৰ।
But not in the. And my learned friend is saying that 9 number of witness they have cited, but it is not in the record. And subsequently, they have not filed any petition regarding the list of witnesses. So, lordship, as per his.
Mr. Kyle, is it the correct position of facts that no list of witnesses has been cited in the final report?
He informed me that there are 9 witnesses been cited. Lordship, normally this type of mistakes never committed by particularly NCB also.
I got in one case also.
Okay, all right. You show me the list.
Lordship, then Lordship will take up tomorrow. Tomorrow I'll on Monday.
You have not filed objection here.
No,
he has
filed objection.
Acha.
But that aspect of the matter has not been dealt with.
And
No. Is the list part of the final complaint? Normally that is a different thing. But my question is, did you file it or not?
I have to make inquiry. Let's say we take up on Tuesday. I'll notice everything.
But here, lordship, one more thing. This person is inside the jail for about non-recovery of contraband from their position, and on the basis of the dummy person. But dummy person also not seized, that is admitted by the seizing officer also.
Dummy person is not?
Means it's through the courier. It's recovered here in Guwahati. 17 point something recovered from Guwahati Sriram courier, and then it's from Golaghat. They call the accused persons. The one another lady is also there. The call over telephone. Then they
Golaghat or Dimapur?
Golaghat. Its office is Golaghat as per the final complaint. Then lordship, what happened? They came next day and showed the note. That note also not seized. And thereafter they were arrested. But the dummy parcel, as per the seizure list, which were seized at that particular point of time, that is not seized. It is admitted by the PW2. I found there in the deposition in the cross of the PW2 seizing officer. He was also one of the team members at that particular point of time. So dummy parcel also not seized, and main contraband seized from.
No, whether a person can be seized. Dummy parcel or?
Parcel.
Achha.
What happened, lordship? In this case, this parcel, one more interesting point here, it is written as they were kept in Tripura police station. They should kept in Dimapur or like that, because it's related to Nagaland lordship. But as per their deposition, I found it. They kept in West Tripura police station. Lots of contradictions are there, and because of that reason, lordship, they are inside the jail for about 3 years, 4 months. And this courier involved in some other case also. In that case, our Honorable High Court granted bail. Sriram courier, na? Sriram Maruti courier. So same Sri Maruti courier. They in this courier, another case also involved. That is also the investigating agency involved. Same investigating agency involved, lordship, NCB, and from there also contraband recovered in the same way. But they did not make the accused or party in this case.
No, that is not the subject matter of this application.
Lordship. But thing is that, lordship, in this case, this persons from whom it was recovered, but that is the courier only. And thereafter they prepared a dummy parcel. Then it was again forwarded to they went to the Golaghat office. Then from there they called up the persons. One lady and this person came, and the lady showed one note to the courier company. Then they, lordship, after that they were there, intelligence officers were there. They intercepted this person, but the dummy parcel must have to seize. Showing the older numbers, that is not there in the seizure list. I have annexed the seizure list at case number 20.
No, that will be considered only at the time of argument of the case. Not at this stage.
But lordship, that is correct. Lordship is correct. This matter of argument or trial. But lordship.
Argument and evidence also.
Lordship, that is
the question is that can this court at this stage appreciate those things?
No, lordship, just to, because lordship, if it would have the initial stage, we would not have any question for them. They are inside the jail for, this person is inside the jail for about 3 years, 4 months. So after it is admitted by this positions admitted by the seizing officer. So lordship.
And the grounds are that?
Lordship.
And one of the ground is that even after elapse of 3 years and 4 months,
lordship,
they could not complete the trial, and only 2 witnesses have been examined.
Lordship.
And the list of witnesses has not been furnished to you.
Lordship.
And any other ground?
Any other ground, lordship, long incarceration, lordship. And lordship, if he produced the list of witness, then we can know.
that whether this witness and from the lower court record, it's not disclosed.
Okay, Mr. Kyle, you produce it on Monday or Tuesday?
Tuesday.
Tuesday. Okay,
But it is not in the lower court record, Lordship.
we'll see. We'll see. Heard Ms. Nargis, learned counsel for the accused, and Mr. Kyle, learned standing counsel for the NCB. List the matter on Tuesday so as to enable Mr. Kyle to produce the list of witnesses. Which is allegedly not the part of the record of the learned trial court. And also of the final complaint lodged by the NCB before the learned trial court.
My lord, can we taken up this matter at 2 on?
Okay,
Tuesday?
at 2 p.m.
Okay.
Timing item 14.
Second appeal arising out of the judgment decree passed by the lower appellate court, thereby the reversing the finding in which the suit was dismissed. The title suit, the appellants were the defendants, and according to the suit was filed by the respondent hearing for declaration of his right title interest over the suit land. And there was a prayer for confirmation of possession of the plaintiff over the suit land in the event of dispossession of the plaintiff during the pendency of the suit from the suit land for recovery of khas possession. So he was just making a mention in the original plea that he was in possession of the property. Now that aspect of the matter, lordship, taken into consideration the pleaded facts and the evidence on record, the issues are framed, and the vital issue was with regard to the exhibit number 4, which was the document based on which that particular exhibit 4 document based on which the plaintiff was claiming his right title interest over the suit land. Now the learned trial court, lordship, framed certain issues. I'm just straightway going to the issues which are framed. It is a page number 82, lordship. And issue number 4 was vital, lordship, and that was accordingly discussed by the learned trial court.
Issue number?
Issue number 4, lordship, this paragraph number 16 in page number 82. On perusal of the pleadings of both the parties and after going through the materials on record, the then presiding officer framed
You are reading paragraph number?
16, lordship, just bottom. After the schedule 2, 3, paragraph number 16 is there. Page number 82, lord.
Yes.
The issue number 4 was with regard to the discussion, was with regard to the right title interest of the plaintiff and possession over the suit land. Now that has been discussed, lordship, in page number 99, because that particular issue dealt with the entire claim that was made by the plaintiff.
Issue number you are referring to?
Issue number 4, lordship, whether the plaintiff is having right title interest and possession over the suit land. So that issue is at page number 99, discussed by the learned trial court. Issue number 4. Got it? Issue number 4. I'm just reading that there's a long discussion, a small discussion. PW1 in his evidence deposed that Ibrahim Ali and his wife, Jahira Bibi, were the sole pattadars of the total land. Therefore, said arrest patta number 130, comprising of more than 23 bighas of land of all dags. Exhibit 1 is the certified copy of Jamamandi arrest patta number 130, wherein the name of Ibrahim Ali is mutated. Ibrahim Ali during his lifetime gifted 4 bighas 17 katas of land in dag number 638 in favor of his adopted son Noor Box by registered deed of gift dated such and such, and said Noor Box being done accepted the said gift and took possession of the said gifted land in the actual locality with specific boundary, and thereby said gift deed was duly acted upon and his name was duly mutated in the Jamamandev arrest patta number such and such, and said Noor Box was possessing the said land and his name was mutated in the said patta. Exhibit 2 is the original gift deed. Said dag number 638 was renumbered in second arrest periodic in patta number 187, dag number 7. Therefore, said Noor Box expired, leaving behind his sole daughter
namely Kamala Bibi, who solely inherited the entire property of said Noor box, and thereby Kamala Bibi was enjoying the entire property, including the suit land. Kamala Bibi expired, leaving behind the only son Islamuddin Lashkar and one daughter, namely Sabjal Begum, who jointly inherited the entire property. Thereafter, above named Islamuddin Lashkar and his sister Sabjal Begum amicably partitioned the properties left behind by Kamala Bibi in the actual locality, and the suit land was exclusively fell in the share of Islamuddin Lashkar. And as such, Islamuddin was possessing the suit land as the exclusive owner, who sold the suit land in favor of the plaintiff by registered deed of sale dated 17/12/2009 on receipt of valuable consideration, and simultaneously physical possession to the suit land has been delivered in favor of the plaintiff within specific boundary in the actual locality. And since the plaintiff is in possession of the suit land as exclusive owner, Exhibit 4 is the Xerox copy of the said deed, which originally is lying in the sub-registry office. Plaintiff is paying land revenue of the suit land. Exhibit 5 is the land revenue receipt. PW3 in his examination chief deposed that he knows the plaintiff defendant and also the suit land, which is approximately 10 kathas. The plaintiff purchased the suit land from its owner Islamuddin, alias Tajul Uddin Lashkar, by executing sale deed and paying cash consideration money. At the time of execution of the deed, he was present there and put his signature as attesting witness. Exhibit 4 is the copy of the deed wherein his name is there, attesting witness. During cross-examination, this is important, Lordship. During cross-examination, PW3 stated that he cannot say as to which document is exhibited as Exhibit 4 in this suit, and his signature is not there. PW4 during his cross-examination stated that he has not mentioned in his chief about the Dag and Patta number of the suit land. He was not an attesting witness in the Exhibit 4 document. He has not seen the transaction of any money with regard to Exhibit 4. Now, on perusal all the evidence put forward by the plaintiff, it appears that none corroborates with each other. Moreover, Exhibit 4, which is the vital document through which the plaintiff is claiming his title, its execution is not proved by the plaintiff as per the depositions of PW3 and PW4. It is pertinent to mention herein that settled position of law is that the plaintiff is to prove his own case, but in this case in hand, plaintiff has utterly failed to prove his case, hence the issue is decided negative. So that aspect of the matter, Lordship, with regard to this issue number 4 for declaration of right to interest and possession of the plaintiff, that was decided negative against the plaintiff, Lordship, and accordingly the suit was dismissed. Now
you tell me, is this a question of fact or question of law?
Lordship. No,
This
Lordship,
is a question of fact or
exactly,
question
this
of
is a
law?
question of fact. But the law point is that, Lordship, the learned law appellate court reversed that finding on the ground that it is for the defendant to prove the case. But as per the provision of Section 101 of the Evidence Act, the defendant is not to prove the case. It is for the plaintiff to establish the fact that he has purchased the property.
Where the court below has observed that the defendant has
Yes,
to prove
Lordship,
it.
I'm coming to that, Lordship. As the appellate court judgment, Lordship, is at page number 33, Lordship. Page number 33, and the issues were mentioned in page number 39, Lordship.
Yes.
Now the issues are mentioned, Lordship, all these issues, whether the plaintiff is having this last issue is paragraph, this issue number 4, in paragraph number 26. Now, after discussing all the materials available on record, Lordship, now the trial court came to a finding, if your Lordship kindly see, the
Trial court.
lower appellate court, Lordship. Lower appellate court came to a finding with regard to the fact that 4. Lordship, kindly see this discussion decisions at page number 43, Lordship. Page number 44, paragraph number 33, point for determination. Point for determination, the first point is that the point for determination number 1, whether the learned trial court had rightly decided the issue number 4, when the learned trial court had held that plaintiff has no rightly interest in possession over the suit land. This particular issue will cover up the entire aspect of the matter, so for the claim of the plaintiff is concerned, Lordship. Now, how it has been discussed, Lordship, point for determination number 1 is a paragraph number 34. I am just referring to the relevant aspect of the matter, Lordship. Relevant paragraph. If your Lordship kindly see the page number 61. Page number 61, Lordship. Page number 61. I will not examine the evidence of the appellant to discern whether he has been able to prove his possession over the suit land. The appellant had examined himself as PW1, Moinul Haq Loskar as PW3, and Jiaul Rahman Barhoi as PW4 to prove his possession over the suit land. PW1 stated in examination in chief that one Ibrahim Mia, Ibrahim and his wife now narrated the entire aspect of the matter, Lordship. PW1. I'm not going to that evidence of the PW1. Now, if your Lordship kindly see the paragraph number 92 in page number 63 with regard to the cross-examination, Lordship, that has been taken into account by the learned law appellate court. That merely putting suggestions to the witness is not sufficient to impeach the veracity of a witness and make his evidence doubtful. In title suit number 89, the respondent taken the plea that Kamala Bibi could not inherit the suit land from her father, Nur Box, being his only daughter. I like to disagree with the aforesaid opinion because there is no provision in Muslim law that only daughter of a person cannot inherit his property. If a person who is governed by the Muslim law dies leaving behind his only daughter, the latter is not entitled at least half share in the property left by a father. But this is not the actual point to be discussed by the learned law appellate court, Lordship. Fact is that Lordship exhibit 4 document which was exhibited by the concerned plaintiff to establish his right over the property. That was proved by way of the taken evidence of the PW3 and PW4. And the learned trial court, Lordship, came to a finding that PW3 and PW4 could not establish the fact or did not make any mention with regard to the fact in which document they put the signature. So the exhibit 4, which carries the right of the plaintiff with regard to the suit land, that was not duly proved. Now the learned law appellate court shifted the burden upon the plaintiff, upon the appellants or the defendant to establish the fact that this particular document is not correct or it has not transferred the right over the plaintiff. But this finding is
you show me wherein the first appellate court has observed and shifted the burden to the defendant.
Yes, Lordship, that I'm coming. Now, Lordship, kindly see the page number 63, 68, paragraph number, starting from paragraph number 107. 108, Lordship.
Yes.
108, Lordship, the admission of the respondents clearly suggests that Kamala Bibi, being the only daughter of Nur Box, is entitled to the suit land, and Islamuddin Lashkar, being the only son, rightly acquired the suit land from his mother Kamala Bibi and had the right to sell the suit land to the appellant by executing Exhibit 4. There is no dispute with regard to that, Lordship. Further, there are no material on record to suggest any other person apart from Kamala Bibi, Tajuddin Lashkar, got the right title interest in the suit land before the same was transferred to the appellant by Exhibit 4. Now, moving on to examination of Chief of PW2, PW2 had stated in his examination chief that on 17/12/2009, the seller Islamuddin alias Tajuddin Lashkar handed over the possession of the suit land to the plaintiff, and from that date, the suit land is in possession of the plaintiff and the defendants never possessed the suit land. Although cross-examined, the respondent defendants could not impeach the veracity and his statement that the appellant is in possession of the suit land and the respondent defendants are not in possession of the suit land has remained unshattered. Likewise, PW3 stated in his examination chief that on 17/12/2009, the seller Islamuddin alias Tajuddin Lashkar handed over the possession of the suit land to the appellant plaintiff in his presence, and at present the suit land is in the possession of the plaintiff appellant, and the defendant respondent never possessed the suit land. Although cross-examined, the respondent defendants could not impeach the veracity. Repeatedly, it has been mentioned, Lordship, could not impeach his veracity and his statement that the appellant is in possession of the suit land and the respondent defendants are not in possession of the suit land has remained unshattered. As the appellant has proved the fact that originally the suit land belonged to Ibrahim Mia and it was gifted to Nur Box, and Kamala Bibi, being the daughter of Nur Box, got right title interest in the suit land, and after her Islamuddin Lashkar acquired right title interest in the suit land and sold the suit land to the appellant, and then the appellant is in possession of the suit land from 17/12/2009 till date, as the defendant could not either prove that the suit land originally belonged to Jahira Bibi and after her to Abdul Wahid and after him to Makhan Lashkar, and they are the occupancy tenants of the suit land under Makhan Lashkar, and also they are in possession of the suit land since the time of their predecessor. They are possessing the suit land openly, peacefully, and without any interruption, and having due force acquired right title interest over the suit land by adverse possession against all others, including the appellant and his vendor with cogent documentary evidence. I am of the considered view that the learned trial court had wrongly decided the issue number 4 wherein the learned trial court had held that plaintiff has no rightly interest in possession of the suit. So the burden entirely shifted upon the defendant lordship. For the exhibit 4, it is for the plaintiff to prove that even nobody came from the sub-registry office to prove the due execution of the sale deed lordship. And the PW3 and PW4, who were the attesting witness, even they also denied the fact that they put their signature in the sale deed lordship. Even they denied the fact that it was a sale deed which was exhibited before the learned trial court. So that is the perversity, and there is order 41, rule 31 is also there lordship. They cryptically, without discussing all the issues lordship, the judgment has been passed.
No, by reading this paragraph number 114, can it be said that the learned trial court has shifted the burden to the defendants?
So exhibit, with regard to the exhibit 4 of the trial court, the finding of the trial court with regard to exhibit 4, but because this is the document based on which the plaintiff is claiming right to interest, there is no discussion with regard to that lordship. How this exhibit 4 has been proved, there should be some discussion. There is no discussion. Merely shifting the burden as per the this section of this paragraph 114.
No. Can it be said that the burden is shifted by the discussion in this paragraph?
Exactly, lordship, because lordship, I just referred to paragraph number 111 and 113. The respondent defendant could not impeach the veracity. We are not supposed to impeach lordship. It is for the plaintiff.
That is regarding cross-examination. In cross-examination, what is the purpose of cross-examination?
Cross-examination to establish the fact which has been narrated, we have to impeach those facts. But the thing is that plaintiff is claiming right on the basis of exhibit 4. He has to prove the fact. He has to prove the document, that this particular document was duly executed, and accordingly it has acquired or it has transferred the rightful interest among the plaintiff. He has not done it. Nobody came from the sub-registry office to prove the document, and the witnesses who were examined to prove that particular two documents, PW3 and PW4, even then there was no discussion on their part. They refused. In the cross-examination, they denied the fact that they put the signature in the sale deed. So the trial court rightly came to the conclusion.
If the first appellate court has shifted the burden to defendant to prove the case of the plaintiff, then there may be a question of law, whether burden can be shifted to the defendant.
Because we have not been able to impeach, but the fact is that plaintiff has to prove his own case. He has not been able to establish the fact. Exhibit 4, which is a vital document, he has not been able to establish the fact that this particular exhibit 4 was ever been executed.
That is a question of fact.
No, lordship, it's a question of law, lordship, because the document based on which he is claiming the right over the property, how it has been proved? That has never been proved. Because nobody came from the sub-registry office, only the photocopy was exhibited.
No, merely because sub-registry officials were not called.
No, why I'm saying so, lordship, because the photocopy was exhibited.
As a witness, does it mean that document is not proved?
How
the document is to be proved?
No, the original was not produced before the court. The photocopy was exhibited. If the photocopy was exhibited, then he tried to prove that particular document on the basis of the evidence of PW3 and PW4. And PW3 and PW4 in his cross-examination denied that fact, that we did not put any signature. And that is what this.
And what about PW1 and 2?
PW1 and 2 are the plaintiff's lordship.
Yes.
PW1 is the plaintiff.
Why they should be disbelieved?
No, I'm not saying about the disbelief, lordship. Then? Because they have PW1 has exhibited the document. So he is saying that was duly exhibited, that was duly executed by the original owner of the property. Now the person who were the attesting witness during the relevant period of time, as claimed by the plaintiff, they denied the fact that we did not put any signature. In the cross-examination, as lordship have just now referred to the finding of the discussion of the learned trial court. So in that view of the matter, lordship, merely by exhibiting a document without following the due procedure of law in exhibiting the document is not the proof of the document, because the plaintiff cannot just go away with the weakness of the defendant, because whatever the strength the plaintiff is having, on the basis of which he can establish his fact.
You see, you read this paragraph again, 114.
Yes,
it cannot be said that the burden is shifted to the defendant.
No, the Anna trial court, the lower appellate court lordship is harping on the issue of adverse possession. Here is not the case of adverse possession, because there is no counterclaim on our part. So only fact is of the plaintiff. He is saying that I am in possession of the property on the strength of a sale deed. Now, how he has proved the sale deed, lordship? That aspect of the matter has not been properly described by the lower appellate court, lordship. Because my adverse possession would come into play only when I'm having some counterclaim. Since I have not filed any counterclaim, there is no question or requirement of establishing my fact that I am in possession of a land for a certain period of time. So that relevant aspect of the matter has been misread or misinterpreted by the learned lower appellate court, lordship. So this is the substantial question of law. Because the shifting of burden of
Mr. Chaudhary,
yes, lordship.
in Madhavan Nair versus Bhaskar Pillai, Supreme Court has said that it is well settled that even if the first appellate court commits some error
Yes,
in
2005.
recording a finding of fact, that itself will not be a ground for the High Court to upset the same.
Exactly, lordship. I'm not on the facts. I'm not on the facts. What I'm submitting, lordship, is the document based on which the plaintiff is claiming is right. Because if you are not, I am just now putting certain mark, I am giving certain marks with regard to exhibit. But if I'm not proving those documents, these are the exhibits by following due process of law.
Those documents were in respect of Exhibit 4, PW 1 and 2 have adduced evidence.
Merely stated that these are
And
exhibited.
their evidence you could not impeach in cross-examination. And therefore the First Appellate Court has relied upon the same.
No, impeach means what, lordship? I have put a query in the cross-examination that whether that has been done by the concerned person. He said yes, it has been done. That much I am not denying. But the fact is that when the photocopy was exhibited, it was for the plaintiff to follow the due procedure of law. So what he did, the witnesses were examined before the court. So witnesses in the cross-examination denied that I did not put any signature in the sale deed. And even I had no idea whether I put a signature in the sale deed. So it creates some sort of suspicion with regard to the due execution of the sale deed. And that relevant aspect of the matter was overlooked by the learned lower appellate court. So this is only the substantial question. I am not having any other. In the order 41, rule 31, all the issues are not properly discussed, lordship. Even I am not on that. I am just on this shifting of burden of the evidence at lordship. This is the only substantial question.
Again, we will examine the matter. Whether the burden is shifted to the defendant or not. If the burden is shifted, then definitely there will be a question of
why I am saying about the burden, lordship, the court came to a finding the lower appellate court with regard to adverse possession. I have not filed any case. I have not filed for recovery of possessions on the strength of my adverse possession. What I am submitting, the person is in possession of the land based on no document. So he has to prove the case that he has a document based on which he is claiming is right. Merely exhibiting a photocopy of a document, exhibit 4, saying that this is the document by which I have acquired my right to interest. This is not the procedure of proving a case, lordship. So that relevant aspect of the matter was not taken into consideration lower appellate court, lordship.
Okay, we'll see. We'll fix another day.
Also,
Mr. Chaudhary,
lordship,
Learned Counsel Court.
Since this 2 IA is there, lordship, inadvertently, lordship, the 3 appellants were there. But I have just in the cost title, I mentioned about 2 appellants, lordship. So I filed one application under order on rule 10, lordship, for correction of the cost title, lordship, with regard to the incorporating the name of one of the appellant, lordship.
Then we have to again issue notice.
No, lordship, I am this appellant, I am this before
Appellant,
lordship.
not defendant.
Not respondent, lordship. Because the Okalatnama was not there, so I was under the impression that he is not intending to prefer any.
Where is the IA?
There's the IA number, lordship, this 3161.
List on next week suggested date.
Any date, lordship.
13th.
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 Lordship,
For further deliberation.
yes, lordship.
On the point of framing of substantial question of law.
Lordship may allow this particular IA, lordship, so that I can file an amended RSA with the this
Which one?
incorporating the name, the 3161, lordship. This is for adding the name of the appellant.
Heard Mr. S.P. Chaudhary, Learned Counsel for the applicant. This application under order 1. Rule 10 of the Rule 10 reduced section 151 of the Code of Civil Procedure is preferred by the applicant for correction of surname of the appellant number 2 and inserting the name of one more appellant who has been inadvertently left out in the cause title of the instance second appeal. Where is the petition and the documents? peruse the petition and also peruse the memo of appeal in RSA number 171 of 2024. Having considered the submission of Mr. Sodori, learned counsel for the applicant, this application stands allowed. Necessary correction of the surname of the appellant number 2 be made and the name of appellant number 3
Yes, Lordship.
be inserted in the cause title. The counsel for the applicant will file amended cause title within a period of 1 week from today.
Before 13, Lordship, because it is.
Before 13, yes.
Always, Lordship.
What about the other?
Other Lordship, the stay and this.
It's the only after admission.
Yes, Lordship, this I'm not questioning.
And number 45.
Only here, already subsequent question of law has already been
framed.
So those two subsequent question law is to be addressed. Now let's try to see the input appellate of judgment. It's page 6. Now we will basically see the case of the plaintiff is there. The in this page 7, paragraph 6.
Page number?
Page number 7 of the judgment, paragraph 6.
No, this is the judgment of
Appellate court.
appellate court.
Yes, sir. Appellate court.
Internal page number 7.
7.
And paragraph number?
Paragraph number 6.
No.
It is also called the memo of appeal. Running page 7.
You are referring to the judgment?
Yes. Running page 7. First original copy has been, I think.
Running page 7.
Yes.
Yes. Paragraph number?
Paragraph number 6.
Hmm.
The respondent herein as plaintiff have issued this suit against the appellant herein as defendant, alleging herein that plaintiff had purchased a plot of land measuring 5 biga, 2 kata, 11 acres, copper pipe, dag number 592 of the 594 of quotation number 157, which is more particularly described in the schedule A of the plan and instructed to possess the same. The plaintiff had alleged that the defendant entered into possession of a plot of land measuring 1 kata 5 plaza out of the aforesaid schedule A land. And this 1 kata 5 plaza is a sweet land and is more particularly described in schedule B of the plan. The plaintiff had alleged that they had requested the defendant several times to vacate the sweet land, but the defendant refused, and the sweet praying for declaration right title interest. Now, my defendant case. The defendant contested the appeal by filing written statement stating him that they had purchased the sweet land in the year of 1981 by registered deed number so. The defendant had further alleged that the plaintiff purchased the adjacent land sometime in the year of 1990. According to the defendant, the land purchased by the plaintiff is not included in the land purchased purchased and possessed by the defendant. This is our case, madam. Our case is that this our 1/5 acres land, not part of their land, that 5 acres of land. So in this regard, in lordship, to find out the correctness of that fact, Amin Commission has been issued. The Amin Commission report specifically mentioned last in his clause that the plaintiff has possessing excess land. Excess land. So in our case is that we possessing that 1/5 acres northern side of the.
Whether the commissioner was examined
Yes, possession was examined.
and the report was exhibited.
Yes, report was.
He was cross-examined on the report.
Yes, cross-examined. That was. Yeah. He was examined as photo witness, my lord. This is. But Amin Commission report has been rejected because some portion of that has not been demarcated. Philosophically, I read it, my person to the read Exhibit X. I was appointed as Amin to survey the Switzerland as per the instruction made in Exhibit X, and I was supplied with a copy of plaint and WS. Before doing survey, I issued notice to both the parties. Exhibit X1 is the notice and Exhibit X2 is my signature. Exhibit X3 is the signature of the plaintiff and Exhibit X4 is the signature for and on behalf of the defendant. At the time of survey, concerning Lord Mondal accompanied me. Both the parties were present at the time of survey. The concerning Lord Mondal took the Chitha survey. I cannot remember the name of Lord Mondal. I was furnished pillars. I was furnished the relevant documents by both the parties. I strictly complied with written
Instruction of Exhibit X.
Exhibit X. Exhibit Y is the survey report prepared by me, and Exhibit Y1 is my signature. Further, there is no mention in Exhibit Y as to what map I relied while serving the Switzerland. In my report, it was not been mentioned that there was no number old map of the Anandanagar village. Fixed pillar was determined as per new map. I surveyed dark number 564592 old of the time Khotian number 117. Different Khotian number come, madam. Village Anandanagar. I did not survey the dark now 592594 of Khotian number 157. I did not survey the surrounding dark 01, the dark of the Switzerland.
Length and breadth.
Length and breadth of the Switzerland are not mentioned in my report, but mentioned in the field book. Exhibit YL is the field book, and Y3 is my signature. And Exhibit Y4 is a trace map. It's a trace map, and Exhibit Y so is my signature. It is not a fact that I did not survey the Sweetland property. Cross, my lord. Caused by the defendant. Balaram did not sign the notice given by me. If Balaram is the plaintiff, he has not signed the notice given by me. Exhibit Z is the copy of the CITA. Exhibit Z1 and Z2 are the draft CITA. As per Exhibit ZL, there is a land measuring 1/5 lesser under DAG number 782 and 130. And Balaram thus in recorded of the in his name. During my survey, I found Balaram in the said land with old that's house, that's homestead. I took surveyed map, etc. from circle office at the time of survey. The old DAG number so becomes DAG number 784, 785, 786, 594, 787, and all new as per new survey settlement. There is land measuring, this is my total land, 6 biga 2 kata 10 lesas in the said that DAG number 782 belongs to Balaram. There is excess land found in the possession of the plaintiff as per my report. Our case is also that, my lord, that we are not occupying their land. Our 1/5 land is outside of that land, their land. And the evidence, the PWs or also deposed in the court that, yes, the appellant residing in the northern side of the Sweetland. Now, they want to try to grab my land by filing the suit that this is the Sweetland land. This is the case, my lord. That aspect of the matter, that part of the matter has not been considered by both the court below. Specific, maybe there is some wrong done by the commissioner, and that ground as a whole, the commissioner cannot reject it as a whole. Suppose it is rejected.
No, Mr. Ahmed, you tell me. The commissioner in cross-examination stated that there is excess land found in the possession of the plaintiff as per his report.
Yes. Yes, this is the case also. I also stated that. He passes on his intact. Now, he tried to grab my land also.
So, what amount of land was in excess?
6 biga land, 6 biga 2 kata 5 lesser land found in the said DAG. And there is excess land found in the possession of the plaintiff as per my report. So it is found in the report, my lord, or that report. Those are the report book also exhibited. It will be found there, my lord. What percent of land? So that is why the evidence sometimes, my lord, the court below has overlooked evidence. That is the one part. And another part is, my lord, here.
About that, I have already stated to you that court cannot, second appellate court cannot re-examine the facts.
Not in every case, my lord. I also given not in every case.
I have seen, but that judgment is of recent years.
Lots of cases are also decided by this noble court. Lots of cases deciding by this noble court also. In similar matter, lots of cases. Even admitted, even heard, even even
maybe, but there are some second appeal where even admitted without framing question of law.
No,
does it mean that I also admit such a second appeal without framing substantial question of law?
No, this is admitted by formulating substantial question of law.
No, that's all right. I'm not referring to that.
Other case is not bound, my lord. It is not. But as far I will examine the matter whether the High Court has the power definitely power, but the lordship give me some judgment, I will look the judgment also. Now, in this case, my lord, already admitted, issue has been, substance question of law has already been formulated. Now, lordship kindly see that apart from that report, whether the learned, would the court bill was correctly pronounced the judgment, my lord? So that, yes, if the Amin Commission report is not correct, they should redemarcate the land to find out the correctness.
No, except the report of the Amin Commission, Amin Commissioner, is there any other evidence?
Yes, PW 1, 2, they are examined, my lord. PW 1, 2, and 3. I give those part also. PW 1 is last see, cross-examine first page. PW 1. In 1990, I was 22 years old. In 1990, I appeared in SSLC examination. I purchased the land and I was present in my house at the time of purchase of the sweet land. I do not know the quotation number of the and other land surrounding in the sweet land. I also cannot say who also possess what quantum of land. I did not obtain non-incumbent certificate prior to purchase of the sweet land. My father taken to the vendor at the time of purchasing the sweet land. I do not know the father of Quddus Ali Bhuya. Quddus Ali Bhuya expired about 3-4 years back. The homestead, Kacha house palace of the defendants is to the north of the sweet land. North of the sweet land. The defendant claimed that he purchased the sweet land in 1980 and they have been residing thereon. We purchased the land in 1990. It is not it is not a fact that present sweet land is not identical with land of TS number 14290. I cannot say who was corrected the quotation number in my affidavit. It is not a fact that I am possessing more than my purchased land by force. It is not a fact that my suit is false and I am trying to grab the land of the defendant. It is not a fact that the defendants never disposes me from the sweet land. It is not a fact that Schedule B land belongs to the defendant side. It is not a fact that the suit is outcome of my evidence thing to grab the sweet land. The evil doing, grab the sweet land. Now PW2, Mir Hussain. I have no land at Anandanagar. I was called by the plaintiff at the time of execution of the deed. I cannot say when the plaintiff got possession of the sweet land. I did not measure the sweet land. My house of original of the sweet land is half a furlong away from the sweet land. To the northern of the sweet land, the defendant has been possessing some land by constructing trellis house. Admitted, they also admitted that we are residing in the northern part of the Switzerland. It is not a fact that the defendants are possessing the said northern like since 1991. At the time of filing of this suit, the plaintiff had possession of land measuring 5 biga. It is not a fact that the plaintiff are possessing the excess land beyond their purchased land forcefully. It is not a fact that the defendant never dispossessed the plaintiff from the suit land. It was not. So this is his evidence. My lord, now PW 3. I am a great writer. It is writer, my lord.
Not necessary.
Not necessary. Writer, not necessary. This is the position. Now, logically, only our case, I have not disputed their position, my lord. I am not at all disputed their lands. Let them possess the land, they take it. They cannot occupy excess land, my lord. But I am a layman, I am a weaker person, they give my land, my lord, by filing this suit. That is why, my lord, first learned court below as well as appellate court below has concurrently erred in law and overlooked the evidence and records, my lord. They should have, suppose, my lord, Amin Commission report is not correct. They should revisit it, my lord, find out the correctness, whether his land is intact or not.
So on what ground the Amin Commission report was rejected?
Because he has not measured the land of drug number, some drug number.
Definitely, he made one omnibus statement that excess land is in possession of the plaintiffs.
It corresponds. But he in chief, he said that he did not measure some portion of land. And on that ground. And it's a finding of the appellate court bill also.
Yes, Mr. Sharma.
So, my submission, madam, is given back only to the fact, or this Kunal directed to measure the land, total land, what person he is occupying, total occupying. Now, my senior,
that remand could have been made before admission of the matter.
The matter already admitted.
Now it has been admitted, but
it is just hearing, my lord. It is already admitted. That is why substance question of law has been framed. It has already been admitted.
Yes.
The Amin Commissioner report, page number 24.
Of the memo of appeal?
Any memo of appeal. Issue number 7 on the bottom.
24. Yes.
The after survey found that the excess land in possession place. The report is silent about the enforcement by the defendant. The Amin Commissioner also admitted that he did not survey the land of tag number 592, 594 of cartel number 157. He surveyed the tag number 564, 592 code. In cartel number 117. The suit land is under tag number 492, again 592, 594. Cartel number 157. From the report, it is asserted that the relation between the cartel number 117 and 157. Therefore, report of the commissioner cannot be accepted, as the Amin Commissioner did not survey the land of cartel number 157. On the other hand, the defendant said cross-examined the PW1 admitted that there is overpossession of the land on the northern side. The suit land of Exhibit A was purchased by the plaintiff, and the title of the plaintiff was challenged by the defendant, neither the boundary of the land or residence. Therefore, it is clear to the plaintiffs have title in Schedule A land. If the defendant are in possession of northern side of X of Schedule A, this they are enforcers and liable to accordingly. It is defined in affirmative. The Army Commissioner report is that number and pattern number is different. And that was rejected.
And that appears to be rightly rejected.
Appears to be rightly rejected.
And then there is no substantial question of law.
But-
Two has gone.
Against that rejection, they have not come before the High Court, challenging the rejection. Therefore, that rejection become final.
Attain finality.
Attain finality. Now, at the second appeal, this report cannot be challenged. And another thing is this, the defendant number 1 and 2, they have no file written statement. They did not examine themselves in the court.
Defendants.
There is no defense evidence.
No, they have filed a written statement, but they have not entered into witness box.
Yes.
Acha.
We are not examining anyone. It is correct. We are not, because fact is correct. We are not claiming their land. We are not claiming their land. And we relied on.
Okay, let him complete. Yes.
If the defendant is not, after filing the written statement, the defendant is not not appeared in the witness box for cross-examination, then the Supreme Court held that what is stated in the written statement is false and incorrect. And that judgment I have, paragraph number 16, you will also can see. Yes. Paragraph number 16. Where a party in the suit does not appear into the witness box and state his
Yes.
When a party in the suit does not appear in the witness box and state his case on oath and does not offer himself to be cross-examination by the other side, the presumption would be that would arise that the case set up by him is incorrect. Therefore, what they have stated in the written statement, as they have not appeared before the court for cross-examination, therefore their whole statement is incorrect. And they cannot, now they cannot get the get it by challenging my evidence. They have not stated in evidence. They have cross-examination, they have applied for Army Commission.
The evidence of the plaintiffs, the plaintiffs were cross-examined by them.
Yes.
Yes.
But the Army Commissioner report is rejected, but against that they have not come. And moreover, my lord, this is a concurrent finding of fact. Now at this stage, my humble submission before your lordship is this. While it is a concurrent finding of fact, there are a number of decisions. The High Court should not interfere. The decision of the courts below. And another thing is this, the decree I have got, that was executed long before, my lord, 21.
Yesterday you have submitted it. Yesterday you have submitted that the decree was already executed.
Already. And there is nothing left. Therefore, there is no question of remanding the matter on the Army Commissioner report.
because the execution was done in the year 2015. Now 9 years has already been passed.
After execution.
Yes. Therefore, the appeal may be dismissed.
Yes, Mr. Ahmed, any reply?
My lord, when the execution is been suppose done, it does not mean my appeal is infectious. If I success in appeal, then automatically we got back the land. And there is some procedure is there, I will got back land. But it does not mean my appeal is infectious. Number one. Number two, my lord, in written statement, I did not read any evidence because not necessary. I am not claiming their land. I am not claiming title over their land, my lord. So not necessary to adduce evidence. And their evidence is sufficient to dismiss the suit. And the board the court below did the, all the evidence, evidence plaintiff and the PW2 clearly stated their evidence, cross-examined that we possessing the land, northern side of the sweet land. Clearly stated, my lord. Though that part of the evidence has been overlooked by both the court below, my lord. So this court has the ample power to interfere with the concurrent finding also.
Ignoring the decision of the Supreme Court. Is it your stand?
Supreme Court decision, I also given 2 decisions, but later on, later part. That may be also.
But I have already pointed out that
Yes, I
those
also already
decisions
pointed
cannot
out.
be
Yes, I will look at it.
read as a precedent.
Yes, I will, I will come through, I will not come through this part. But however, these 2 judgment I relied matter, the lordship may mention, whatever it is applicable or not applicable, I place before the lordship. That one. One is 2018 Supreme Court, 18 SCC 303. Paragraph 14. 20, etc. And another is, my lord, 2021, 12 SCC.
You furnish copy to the court.
Yes, yes, I have. 1, 2. Full bench decision, my lord. 2012 SCC. Paragraph 13 order and
Or Mr. J. Ahmed, learned counsel for the appellant, and Mr. A.C. Sharma, learned senior counsel, assisted by Mr. Bhardas, learned counsel for the respondent. Argument concluded, judgment reserved.
I'll submit this to hello, like my lord.